Good morning, Mr. Lowe.
Good morning, sir.
Are you? I'll ask the court staff to swear you in to give evidence. All right. Thank you.
Thank you.
Good morning, my lord. Good morning, Mr. Lowe.
Good morning.
Could you please state your full name and occupation for the record, please?
Yes, my name is Jimmy Lo Yu Huang. Jimmy is my Christian name, and Lo Yu Huang is my Chinese name. And my profession is that I'm a property development consultant and an expert witness.
Thank you. Could you please confirm if you're taking an oath today or an affirmation?
Affirmation, please.
Thank you. Could you please repeat the following statement after me? I solemnly declare
I solemnly declare
and affirm that the evidence
and affirm that the evidence
I shall give will be the truth,
I shall give will be the truth,
the whole truth, and nothing but the truth.
the whole truth, and nothing but the truth.
Thank you, Mr. Lowe.
Thank you very much, Mr. Costello.
Thank you. Mr. Lowe, we have a limited amount of time, but we'll try and do this as quick as we can. Your full name again, please, for the record.
Jimmy Lo Yu Huang.
And it's right to say that you provided an expert's report.
Correct.
The pages are G1 to G56, is that right?
Yes, that's correct.
And do you adopt the contents of that report?
Beg your pardon? Adopt?
Do you agree with the contents of your report?
Yes, I do.
Just very briefly, what is your experience in terms of your expertise?
I graduated as an architect in 1980 and been practicing ever since then, so I have 42 years experience covering UK, Europe, Asia, and in the last 17 years in Dubai, UAE. And during that time, I have developed my skills and expertise as a technical expert regarding technical issues, including delay and quantum, which I have assessed in the past. And in particular, as a project manager position, in my position, I authorize payments and determination of delay. So I audit delay and quantum issues.
Okay, so we know that there are 3 periods of delay in this case. Delay period
Correct.
number 1, do you have any comments on that?
Period number 1 is fully excusable in accordance with the SCA.
Okay, and delay period number 2, do you have any comments on that?
Delay number 2 is excusable with qualification, in the sense that I think both parties have agreed that there were delays caused by various contractors and so forth, including the main contractor itself. And because of the fact that Mr. Lee's report has very clarified that there was no as-built plan as such, and to determine any delay analysis, I would concur that I would determine that the period of delay in this period 2 is a concurrent delay.
Okay. And with delay period 3?
Period 3 not excusable in my opinion, because again, Mr. Lee has determined the fact that the programs provided by Reem was full of anomalies, and he was only relying on certain issues of logic. He referred to primarily the WIR, the close-up program, the workspace handover, the WhatsApp messages, and the variations as to substantiate his delay, which I do not agree.
And why is that?
Because number 1, the close-up program is primarily, as I reviewed it, is mostly finishing and snagging work. It's not the main works itself. Number 2, the WIR shows a sequence of works that were not fully approved in that respect, and it's not completed and part of the main works. And the variations were primarily relating to the defects works, rectification defects works, which is still part of the main works, and therefore cannot be justified to substantiate a delay.
Okay, I want to move on prolongation costs. Are prolongation costs recoverable by Reem? And if so, what period?
They're fully entitled to claim prolongation costs for the period 1, because this is in accordance with the SCA. Period 2, as I say, is a concurrent delay, and there's no entitlement, and obviously there's no EOT entitlement in period 3. Therefore, prolongation cost for that period is not applicable, in my opinion.
And period, oh, you said period 3 as well, yes.
Yes.
Now, in relation to indirect costs, which are part of the prolongation costs, do you have any comments in particular on that, or any opinions?
The indirect costs on that part, let me just think carefully, the indirect costs, my apologies. Yes, in the respect that Mr. Paul Craig prepared a spreadsheet regarding all the team that was claimed for the time on site, but I do not see fully the extent of his substantiation in respect of his spot check. In his report he mentioned whether he covered in detail the relevant people who were actually on site against daily progress report on the resources that was available or attended the resources on site at that time.
Okay, moving on to overheads quickly. Mr. Craig provided a formula or a table or a method of calculation. Do you agree with it?
Not fully. The Emden formula has a tendency to have double accounting purely because the figure of the contract sum of 47 million is already include profit and overheads, and the figure he used in his exhibits for the 3 audit accounts, in my calculation, do not match what Mr. Craig has used, and in my opinion, Mr. Craig has made an error. And secondly, sorry.
Carry on.
No, that's primarily, I mean, in his first report, he used 720 days, and obviously in the joint meeting that we had, he took the liberty of changing that in his addendum report when I highlighted that issue.
In paragraph 47D of my skeleton argument, I don't need to take it to you, we can look at it later. There's another method of calculation based on the annual profit of the defendant. Do you agree with that calculation?
Yes, I've seen and reviewed it, and it is in accordance with my thoughts, my assessment.
Nearly there, nearly finished. But just dealing with variations, we know that there are negative variations. Mr. Craig applied a proportionate percentage of 5%. Do you agree or disagree with it?
No, I do not. I do not agree.
What's the appropriate percentage?
Well, as Mr. Craig made an allowance of 5%, in my practice, it's between 2 and 5%. But I will use the 5% for the benefit of his calculation. However, as an architect, this 5% is split into various stages of work, and I determined that it is only 35% of the 5% is applicable to Reem's work, because obviously they do not do concept design or detailed design, they were doing shop drawings. And in that respect, 35% of 5%, I think if my memory recollect, is 1.75% is applicable, not the 5%.
Okay, and you just explained why that is as well.
Yes.
And the final question I've got for you is in relation to interest, recovery of interest. And do you have any comments on that as well?
Yes, I do. I understand where Paul Craig is coming from in his tabulation. He just did the numbers and the dates and so forth. But in the first 3 items, which I noticed was for the 3 advance payments of 10% each of the 47 million, which is 4.7 million each. And he has calculated it without the table a long duration of delayed payment. But in accordance with the SCA, one of the key conditions for any release of payments for advance payment is that Reem must submit their performance bond. And in review of the documents provided by Mr. Nabil in his witness statement, I noticed that the performance bond was dated 1st of August 2018. Therefore, any payment before that is not relevant. And in my opinion, the calculation and the delay used by Mr. Craig in that respect is not applicable.
And what about the payment certificates?
The payment certificates, there is a reference again in compliance with the SCA. there was a limit. I can't remember the date exactly. I think it was up to March 2017 to be paid. So any certificates beyond that from the main contractor, this is, and beyond that, and that was another reference to PC 19, if I recollect, and by the main contractor. But I need to qualify this because this PC 19 says from the main contractor, but in Mr. Paul Craig's table, there is a PC 19 listed for Reem. So if it's the same, then the dates will be those payments, progress report payment will not be applicable in the calculation.
Thank you very much, Mr. Lowe. Those are the only questions I have for you, my lord. Those are my questions, so it will be for Mr. Carvelis to cross-examine Mr. Lowe.
Mr. Carvelis, when you're ready.
Good morning, Mr. Lowe. Pleased to meet you.
Good morning, Mr. Carvelis.
Can you hear me? Can you hear me well? Is it loud and
Yes,
clear?
I can. Yes, I can.
Thank you. Great. It will be quick. I won't keep you long. Let's establish some background first. Do you consider yourself primarily a delay or a quantum expert?
Primarily delay?
Or quantum expert?
Delay expert.
You're primarily delay expert. Thank you. And is this the first case that you work with 5?
No, it's not the first case.
How many other cases before that?
2 cases about 3 years ago.
And were they court trials, arbitrations, or claims consultancy?
It was arbitration as an expert.
As an independent expert, presumably.
Of course. All my expert services are always independent.
For delay, for quantum, or for both?
It's mostly the technical issues.
For technical, neither delay nor quantum.
No.
Okay. Thank you. Now, this question has nothing to do with your credibility. It has nothing to do with your testimony, but I need to ask it for another issue another claim that it is also a matter in this trial. Your fees are paid by 5 Real Estate Development or another 5 group entity?
5 Real Estate, because my appointment is with 5 Real Estate.
Directly. Okay, thank you. I will look at your report now, and we will start with the delay issue first. I looked at the report from page 1 to page 52 to the last page, 53. It seems to me that you don't have any separate section for the delay. Am I right?
Can you repeat that, the first part of your question?
It seems to me, looking at your report, that it is not split between delay and quantum. There is no separate section for delay. Am I right?
Well, just touch on a small subject. No, it's not split as such in the structure of the report.
Okay, and the relevant part of your report, where you do touch upon delay issues, is at section 8, which starts at page 25 of your report, G28 for the bundle, Your Honor. Did you see it?
Yes, I can see it. I'm using my hard copy, my lord.
Oh, which I think is very helpful. Your Honor, do you need me to project on screen, or can we proceed as?
I have it, thank you.
Great. Now, if we look at it, so you deal with delays in the context of delay penalties. If we go quickly through your report, you will hopefully, I assume you will agree with me that 8.1, the entire of 8.1 is basically a background and an introduction, correct?
Yes.
What's interesting here is in paragraph 8.1.7, where you say that you have not seen a time impact assessment, and then you say that I cannot fully opine Reem's claims. You see this, I guess?
Yes, I have not seen any submissions of RES detailed impact. Well, it should be analysis rather than assessment of the delay events.
Okay. It seems to me, I don't think we need to spend a lot of time, that the most relevant to the delay issues parts of this section of your report is paragraph 8.3. Will you go, can you go there, please?
8.3.
8.3, yes.
Yes.
And it is then two paragraphs, 8.3.1 and 8.3.2.
Yes.
And there you say that you refer to Mr. Akiki's second witness statement of March, especially to specific paragraphs, which we will see.
Yes, I can
You
see
say
that.
there that it appears that they support Mr. Akiki's statements that Reem have caused delays, correct?
Yes.
You see this, right? And then in 8.3.2, you make a statement that, well, actually an opinion, you give an opinion. What the document produced by Mr. Akiki shows. You give your opinion. Am I right?
I'm lost with your statement.
So in 8.3.1, you make reference to the witness statement of Mr. Akiki, where he presented his delay, he introduced his delay analysis.
Yes.
See this, and in 8.3.2, you give your opinion.
Yes, that's right. I mean, it's very clear. If the as-built as planned dates provided are substantial, this statement.
Okay. And we will look at especially this paragraph 8.3.2 later on. And then we have the conclusion, right? You see,
Yes.
we have the conclusion, which is just a conclusion. So if I say that your overall contribution to the delay discussion in this case are these two paragraphs, will I be wrong?
Yes, because I was limited to the fact that there was no EOT submission made by Reem. I understand from Mr. Lee's report, the only EOT submission made was after I think in October or whatever, the end of 2020, after the determination.
I see your point, but my question was slightly different. Your contribution not as to whether there was or there was not an EOT application. Your contribution as to actual assessment of the factual situation on the project and your own personal assessment of what delays caused the late completion of the project and the liability for these delays, we can see it in these two paragraphs. I haven't seen anywhere else in your report, that's why I'm asking. I may be wrong. If there's anything anywhere else, point it to me.
Yeah, the comments is short in this paragraph purely because if you look at 8.4.2, I have not seen any evidence to substantiate RES Reem's that is claimed that the delay was fully caused by either China State or I think what
We
I'm
do
trying to
not-
say is that my report is limited because there's not sufficient information submitted by Reem to determine, to make any assessment.
So what you're saying, let me rephrase then. What you're saying is that you could not assess Reem's assessment, Reem's claim, correct?
Yes,
And your assessment, because I assume you will agree with me, the engineer has already refused an extension of time with their determination. And you presumably you will agree with me that Mr. Akiki, in his delay analysis, argues that all delays, that the sole cause of delay is Reem. Your assessment, your examination of Mr. Akiki's argument, Five's argument that Reem is the sole cause of delay, can be found in these two paragraphs, 8.3.1 and 8.3.2. Am I clear?
well, you made a very long statement, and I will clarify each statement that you've made. In the first part, you mentioned about the engineer's determination. I have not seen the engineer's evaluation of that part. You know, I mean, at the end of the day, I refer to Mr. Lee Spaulding's statement that the extension of time made submitted by Reem was during the course of the proceedings, not during the course of it was before the engineer's determination in March 2020. I think that I want to make that very clear. So at the end of the day, if the engineer didn't have that information, therefore it's not substantiated. That's the first part. And because of the lack of this information, I equally cannot make any substantiation of assessment, should I say. Rephrase that. I cannot make any assessment of Reem's. Can I finish, please? I cannot, because of the lack of substantiation on information, I cannot make an assessment. This is why my report is very limited to the next statement you make to Mr. Nabil's analysis. Because at the end of the day, I want to emphasize that Mr. Nabil's assessment, logically, because there is no information of as-built plan as such, we follow logic. And the logic that Mr. Nabil emphasized is the logic of the building, level 59 being the last floor. And the last floor is, there were delays, as I mentioned to answer earlier to Mr. Costello's question about period 2. There were delays by all parties, which is fair. I conclude that. But there is a limit to this delay, and that limit of delay was established by Mr. Nabil with the logic of level 59 being the last floor. And therefore, after this level 59, because of in the baseline program of Reem submitted that I've seen, that was established by, that was illustrated by very clearly by Mr. Lee Spaulding, it was in stages A, B, C, D, E in batches of floors, and it goes outwards. So the last floor is 59, and Mr. Nabil, to be fair, he was being fair in his analysis that level 59 is where any delays up to that must stop. Anything beyond that is by Reem. And based on the evidence I have seen, I agree that these were delays caused by Reem.
Right. Okay. Let's go back to my question. Did you see the engineer? Did you read the engineer's determination? Yes or no?
Yes, I did. I think you've seen my report. I refer to most of my comments are based on the engineer's determination.
Excellent. And you say, because my question was not whether Reem made an application for extension of time. My question was whether you considered the evidence available to confirm that Mr. Akiki was right. It's a slightly different issue. Have
Yes.
you selected? It's a very simple question. have you looked at all evidence available in order to confirm that Mr. Akiki was right?
Yes, I have seen the evidence,
Excellent.
including all the
Yeah,
variations and the other letters.
I'm
And
sorry, I
you
didn't
have
hear
seen-
I didn't hear the answer. I'm so sorry. I just didn't, I think it was just me. Could I just ask for the answer to be repeated so I can make a note?
Yes, I support Mr. Nabil's assessment because there were a number of issues, including defects, major defects, and works not completed.
Okay, we'll go to all those. I will give you the opportunity to do this. We'll go into details. Now, I'm looking at the. I'm looking at your expert opinion in 8.3.1. Your words are the following. I refer to Nabil Akiki's witness statement of 24 March, and especially you mentioned two particular paragraphs, 60 and 61, and rely on the exhibits supporting this statement. This is what you say here.
Yes.
Upon review of these documents exhibit, it appears that they support Akiki's statements. Reem have caused delays due to late deliveries of material for the works. Do we agree? I think it's obvious. This is what you say here, right?
Yes. Yes.
So my reading it, my understanding is that you looked at Mr. Akiki's statement, you read these two paragraphs 60 and 61, correct?
Yes, and the exhibits associated with this.
Yes, looked at, reviewed these documents exhibited, presumably in paragraph 60 and 61. Yes, these are
Yes.
the documents that are there. And then it's your impression, your opinion, it appears that they support Akiki's statements. That's what you did.
Yes.
And you issued your report on, what is the correct date? 25th of April 2022.
Correct.
And at a time when all witness statements by both parties had been submitted.
Yes, correct.
And after the production exercise, documents production exercise, correct?
What do you mean by production exercise?
The evidence documents, it's a process within a trial which precedes witness statements, precedes expert reports, where each party provide all their supporting documentation. And there were a lot of documents, thousands of documents that were produced. So you issued the report after this stage. This stage, it was in January or February, if I recall, a few months before your report.
Yes.
Did you look? So you looked at these documents, all those documents provided, when you say that it appears that they support.
In my report, I rely on only the exhibits produced by the witness statements. If you're saying that there was another package, if you're saying that there were another thousands of documents released between the two parties, I have not seen all of them. No, I only rely only on the witness statement.
Thank you. That's exactly what I was trying to establish. So you issued your expert opinion on the basis of paragraph 60 and 61 of Mr. Akiki and the documents exhibited on these statements.
Correct.
In 8.3.2 now, if I take you there, you make an interesting selection of words, if I can say. There is an interesting selection of words. First of all, it is the words that are missing that are interesting here. You refer, it is the second part of this sentence, to the document provided by Mr. Akiki as this simple illustration. Do you see this?
Yes.
The document that this, which is this simple illustration, exhibit NA 31. We can have it on screen if you don't have it already available, although I'm sure you know it.
I recall it, yes. I think it's that it's diagrammatic.
For the record,
Sure.
excuse me, for the record, it's E Echo 1094. Your Honor.
Thank you.
Which is what Mr. Akiki has referred to as the delay analysis.
Yes.
Is this a delay analysis? Is it a delay analysis or is it a simple illustration?
It's a simple analysis. I mean, if you want me to be very clear at my simple illustration, what I mean by that is that it is, I think we've heard evidence given by Mr. Nabil that, it's not prepared in accordance with any protocol.
Excuse me, I missed the last part. If you can repeat it, it wasn't very clear.
I recall in the evidence prepared given by Mr. Nabil earlier, I concur with him. My explanation is this is a simple illustration of an analysis.
So does it satisfy this? You said you are a delay expert, primarily.
I'm not a delay expert as per se in the terminology. I have sufficient experience to read and determine a delay analysis.
And draft also a delay analysis, sufficient experience to prepare a delay analysis?
Yes, in this format.
All right. That should be enough. So in your expert opinion, does this document satisfy the requirements of a delay analysis?
At this stage, yes.
You are of the opinion that it does?
Yes.
Yes, your answer is yes. Excellent.
Sorry, can I also confirm that at that time, the dates provided are substantiated, and the dates are substantiated by the evidence provided by Mr. Akiki in his reference to all the attachments?
Yes, but this is what you looked at. We established it. You looked at paragraph 60 and 61 of Mr. Akiki. You looked at this exhibit, which you expressly mentioned, and you look at what other documents are referred to in paragraphs 60 and 61. That's what you just told us. I don't know if you want to change it now, but it's what you just told us. And looking at and we will see the documents that Mr. Akiki exhibits in these two paragraphs. Which are three, by the way. Three. As I read it here, in paragraphs 60 and 61, we have four, I think, not three, four documents. Anyway, you say you use the words as planned / build, correct?
Sorry? As planned.
As planned / as build. In 8.3.2, you use the words as planned, as build. Right. Now, I assume looking again at this simple illustration, as planned is the upper part of this diagram,
Correct.
as per the project schedule. As built is the lower part.
Yes.
Right. And it is as built as at 9 September 2018 in relation to concrete completion. Roof garden saves completion, 3rd March in relation to roof garden aids completion. 28 February as in relation to balcony saves completion. And 30 January 2019 in relation to tiling completion. These are the as-built days.
Correct.
We
In
agree on
accordance
this?
with the attachment. Yes. These are as built
Yes.
as extracted by Mr. Nabil in his comments, refer to attachments 7, 8, 9, and 10. These are the true documents of what we call the work inspection request. And
Okay.
this is the major record of works when they are completed.
It's not an issue. Our discussion is not about this. It's slightly different. So this analysis here is an as-built versus as-planned, where the as-planned is the amended completion dates with the under the contract, and the as-built are completion dates of certain activities not at the actual project completion, but at the time that those activities are supposed to be completed. Is it clear? It is not an as-built with reference to the project completion date. I think we can agree on that.
Yeah, based on this information here, I think Mr. Nabil has really clearly expressed that, what you stated.
Okay. And everything from 3rd of March 19 until 2nd of September, everything in the future is a projection, because at line 9, last
Yes.
line, you see that there is this famous red arrow which counts the period from 15 March to 2nd of September. You see this?
Yes, I see it.
So from 15 March to end of September, it's a projection.
It's
It
not
is
a
not
projection.
as-built.
These 2 dates from 15th of March to the 2nd of September are facts. It's not a projection. This analysis prepared by Mr. Nabil was after the project, not during the project.
Yeah, but
Your terminology projected future. This program was not prepared, before that. This was prepared after the event, so this information are facts.
So at the time that it was prepared, we knew what happened after the 3rd of September until the 3rd of March until the 2nd of September, correct?
Yes.
So there was nothing preventing preparing an as-built, the as-built date to be 2nd of September 2019.
Well, you
At
don't
the
prepare
time this was
Sorry, I have to cut you short there, Mr. Cavalis, because you've been making so many statements. I will answer each statement as you may.
No, I made one statement only. And it was a very simple question. If at the time that this analysis was made, they could have used 2nd of September as the as-built date.
I don't follow you.
You don't follow me.
Yeah. It's a bit confusing.
Yes, it's not in reality. If you have an experience in delay analysis, it's not confusing. Let me put
No,
it.
it's the way you put it, sir, with all due respect.
I'm absolutely sure that you understand entirely what I'm saying. I will rephrase though. We have a delay analysis which was issued, Mr. Nabil Akiki told us yesterday, at the beginning of this year. Do we agree so far? To break it down, to make it very simple.
Yeah, I think Mr. Nabil said it was prepared for his business statement.
For this,
At the beginning of this
you are
year.
correct.
Right.
Yes, and his witness statement was in March, so I think it was at the beginning of this year.
Yes.
I think we can agree on that, right?
Yes.
This is a delay analysis of what happened in the project, which was completed on 2nd of September 2019. Do we agree that?
Well, let me put this way. As an expert of reviewing everything, the date used by Mr. Nabil, 2nd of September, as the completion, I will use the word completion as the date where it stops in the calculation. Based on all my assessment, I would say the delay was beyond the 2nd of September. I want to express that as an opinion.
I have no problem to agree with you on this. It actually extends the period of prolongation cost that my client could claim. So I would very happy to agree that completion was 15th of September, 30th of October, 31st of December. The longest we go, the bigger the bill. But it is agreed by everyone that the hotel opened on September the 2nd.
Yes, that's the date that Mr. Nabil has used.
Okay, excellent. So, Mr. Nabil, in this analysis, in this document, ignores all facts after his as-built dates and the real as-built date, which is hotel opening. Can we agree on this, that those facts from 3rd March, after 3rd March, are not reflected in this document? It's not controversial and it's not so complicated as a question.
It's not controversial. I mean, it's correct. There were no records of any other activities of completion which were delayed.
This is what I was trying to establish. And I cannot help but asking this question, looking at this here. Again, we're looking at this document. You see the bottom part of of this illustration. We read line 2, for example. Line 1, concrete completion, brackets, factual date. You see this?
Yes, I see.
9 September 2018.
Yes,
what?
Correct.
Now, I put to you that when I read concrete completion, factual date, maybe I may not be the brightest person on earth, but when I read it, I understand that Mr. Nabil meant that on 9th of September 2018, all concrete works were completed, and this is a fact, factual date.
Yes.
Do you understand something different than me?
No, I think Mr. Nabil has illustrated that in his extraction number 7.
And presumably this applies to roof garden age completion, balcony age completion, and tiling completion.
Yes.
And that's all I had about delays. Let's move now to one more issue, which will be, again, it will be really quick. I promise. Variation. Now, you say in your expert report that you are not a lawyer, of course, but you do have 40 years of experience, so you are versed with, you are familiar with construction contracts like FIDIC and other forms, right?
Fully correct.
No. You will agree with me then that in a lump, there is a big difference between a lump sum contract and a remeasurement contract. And the
Agreed.
difference is that in lump sum contract, the client, the employer, pays the agreed contract price without actually taking the tape and measuring how many cubic meters of concrete, for example, were poured. While in a remeasurement contract, they do an actual remeasurement. I think it's common law knowledge. This is, don't think we can disagree on this.
Yes.
Right. And I think you will agree with me that in a lump sum contract, the scope is defined at the time of signing the contract. Correct?
That's very important. Yes. I mean, at the end of the day, the lump sum contract is, we know in general, what you just described earlier is the principle of it to a certain extent. It's always subject to whatever clauses that has been included in the agreement.
So it is really important, the scope of the works at the time of signing the contract. Do we agree?
Yeah, the scope of
That's
work.
the really important.
Yeah, it's a design and build.
Excellent. So in a lump sum contract, I'm glad we established that the scope of work at the time of signing of the contract is important. Now, and I'm sure you will agree with me that if there are additions to the scope, the contractor is required to be paid extra.
If there's a variation supporting that addition, yes.
Yes, and I will agree with you that in order to find this addition, a sort of remeasurement will be probably required. Not necessarily, not in all cases. If there are unit rates, maybe there is no need for a remeasurement. But in some cases, there may be the need for remeasurement. Do we agree on that? You say it in
Yes.
your report already.
Yes.
We agree. And I'm sure you will agree with me that where there is an omission from the scope of work, then the employer is required to compensate the contractor, usually for the lost profit, because the contractor went, and the basis is that the contractor quoted, gave a price for a specific scope. If the scope was different, his price might be different. I would like to think that this is common knowledge, and you will not have any difficulty disagreeing with me. I'm just trying to establish that we are on the same page.
To a certain extent, yes. I mean, that is a fact that there is profits and overheads. But in practice, if the parties are usually amicable, this will not be taken into consideration.
Okay, we'll see what happens in practice. But before we do that, let me ask you again. Before, at the time that you prepared your expert report, did you read the parties' submissions?
Yes. You mean when you say the party
Oh.
submission, you mean the pleadings?
Yes,
Yes.
the pleadings. You
Yes.
read the pleadings.
Yes.
And you looked at the documents referred at the pleadings.
Where applicable, yes.
Where applicable. It's your duty to, I'm sure you know.
I mean, obviously when it's applicable to that statement, where it refers to, yes.
Okay. Okay. So you looked everything that was related. And before giving evidence today, you watched the trial, the first 3 days of the trial, obviously. I think you did. I think I saw your name. And
Yes.
did you have the opportunity to read the parties' latest submissions, which are the skeleton arguments?
Yes.
You did. Then hopefully we will go quickly then. Now, one of the heads of claims in this dispute are variations, the disputed variations, which are in reality omissions.
Yes, correct.
I will summarize also for the benefit of the court, and correct me if I'm not accurate, please. The engineer, in his engineer's determination in March 2020, after project completion, after hotel opening, to use a non-controversial expression, found that 5 was entitled to make 3 deductions for omissions. Am I correct so far, Mr. Law?
If I recall, if you say from that, I can't remember exactly 3, 2, 4. It's around that figure, yes.
Take my word for it. I will
Yes,
be corrected if I'm not accurate. Actually, the value, this was the scoping of aluminium louvers, stick curtain glass, glazing doors, balustrade, and stick curtain wall panels. And there were 3 different deductions acknowledged, recognized determined by the engineer for 430,000 and change, for 2 million, almost 200,000, and for 570,000 dirhams. So you do the math, it's what? 2.2 plus 6, 2.8, 3.3 million dirhams, give or take. Right?
If you say so.
The engineer determined that these were omitted, and therefore they had to be deducted.
Yes.
And the engineer determined that may I put it as a question? In your understanding of a lump sum contract, if the engineer determined that louvers, for example, less louvers were used than those quoted, does this entitle the engineer to deduct? If he measured, if let's say the scope provided for 100 louvers, And then he measured how many louvers were used, and he found that they were 80. Is he, in your opinion, entitled to deduct the value of the 20 louvers that were not installed?
Well, my reply to that is that it's not as well as it's not in accordance as you described. If I'm not mistaken, the major part of the scoping works were levels 18, 19, 39, and 40. These 4 floors were the service floors or mechanical floors, for clarity, and they do not need this scope of works that was the scope. So in that sense, there is an error somewhere along the line where this was included by Reem, and it was not picked up, and these service floors do not need the same works as the typical floor, and that is a very critical part of it. And
So
it's not so much like you say that I'm not counting 100
we'll
movers.
go to the.
Can I finish? You're not counting
If it
100
helps,
movers.
Mr. Lo, listen to me. If it helps, I will take you to the actual instruction of the engineer of describing what you just said. We will go, I will show it on screen, the actual instruction of the engineer. So I'm not, we will deal with what you just started to describe. My question was slightly different, though.
The answer to your question is that yes, in my opinion, it is entitled to deduct, the 5 was entitled to deduct the scoping of the works.
So your opinion is that in a lump sum contract, if the engineer or the employer measures a piece of work at the end of the project and he finds that the volume, whatever the unit, the measure of unit is, cubic meters, centimeters, whatever. If he finds, if he finds that it was less, if he measures at the end and finds that this unit, this item of work was less than quoted, he can deduct. This is what you're saying.
No, I want to clarify very clearly. The way you apply it is that at the end of a project, if an engineer determines that the quantity used, if you use using a fine comb to determine that the quantity is less and deduct in general as a project, then that is not applicable. However, I said it earlier, the conditions of the terms and conditions of this SCA allows the 5, as the employer, to vary the works as they deem fit. So, as much as you say it's a design and build lump sum, the conditions attached to this lump sum project in the SCA allows the employer, which is 5, to deduct or not deduct the scope or vary the work. I think it's a better word. I'm not mistaken in the wording.
But I do not disagree. I do not disagree with you that the subcontract agreement permits omissions. That's not the issue of our disagreement. Of course it does. My question is different. And I'm sure you understand what I'm trying to say.
Yeah, I think
you have a lump sum contract. Let's forget for a moment if it allows or does not allow omissions. I agree with you. It does. Let's forget about it for a moment. I'm trying to establish the principles here. What I'm asking is if a remeasurement at the end of the works is considered an omission or something against the concept of a lump sum contract. not where there is an instruction to omit. This is different. There is another issue with that. I'm not talking about this. Let's assume that there is no instruction to omit for a moment.
Agree to the extent that if there were no instructions, no variations, the job went ahead smoothly, the lump sum cannot be remeasured. That I agree.
Okay.
If there's no other instructions.
Excellent. And you will know, and no doubt you will agree with me that the instruction to omit must be issued after the contract has been agreed, has been entered into, correct? Yes?
Yes. Subsequently, whenever it's appropriate.
And very often, even when there is an instruction to omit, the contractor, the employer may omit, but the contractor is still entitled to compensation, some compensation for this omission. Do we agree on this?
It depends on the particular instruction and so forth. I'll give you a very typical, as an architect, I issue a lot of instructions of variations. I'll give you a very typical example where a variation, even if I give an instruction, there is no variation applicable for positive or negative. Let's say, for example, if my specification for the wall is green, I give an instruction to change the color to blue. It is an instruction and a variation to the specification, but there's no cost because the instruction was given before the work was done. This is as a typical example.
But
so it's all subject to the issue.
I will agree with this. Of course, we agree with this. I'm trying to establish the principles. I think we finally did. Now that we established the principles, let's go to the facts surrounding these omissions. Now, you are aware, I don't put it as a question because it's in your expert report in multiple instances. But correct me if I'm wrong. There was a works order issued in 2016. Are you aware of that?
Yes.
You are.
It's been mentioned in the last 3 days, yes.
The works order was for, I think you mentioned it also, the original quotation was for 48 million and change. And finally, Reem made an offer for 47 million, 47, and the works order was based on this 47 million scope, correct?
Correct.
Yes. This works order was issued by 5, correct?
Yes, I understand so, yes.
Reem was not, for reasons which are controversial, but it's not a matter that we need to discuss, did not enter, although Reem is a subcontractor, is the glass subcontractor. They never entered into a contract with China State, the main contractor. You recall this?
Yes.
And they finally entered the contract. Again, the circumstances are controversial, but irrelevant for our discussion, with 5. It's the famous SCA. You know this.
Yeah, under
right?
the SCA. Yeah, under the SCA dated 28th of May, signed on 4th of June.
Yes. And the SCA was entered into on 4th June
Of June.
2018. 2018. So
Correct.
We have a works order in April, I think 16, but I may be mistaken. April 2016 for 47 million worth of works. That was the quotation. And then we had the subcontract in June 2018.
Correct.
You agree with me, right?
Yes.
And the contract price was again 47 million.
Yes. if I recollect, yes.
No change in scope.
Sorry?
No change in scope. Same scope, glazing works.
Yes, the
Glasses,
same. Design
change
and
scope.
installation of balustrades, frame, aluminium works.
Excellent. Let's look now at, and the engineer said, hang on, at the end of, when the engineer was requested to determine, he realized that, hang on, I had omitted some parts of the works. Previously, I issued notices for omissions. I have to deduct them. And he did. Let's have a look when these notices, now, before that, we argued that, and this is in our counterclaim, in paragraphs, which is why I asked if you read the parties' pleadings, in paragraphs 3.1, 3.2, and 3.3 of the counterclaim, our argument was that, Reem's argument, that the engineers should not have made these deductions because these instructions to omit were never issued as a document entitled omission. That was our argument. Please take my word for it. If you've read the submissions, you'll know what I'm talking about if you read the pleadings.
Yes, I remember reading it, but I can't remember the full details of it.
Okay. At paragraph 5 now of 5's defense to counterclaim, 5's defense was that that's nonsense what Reem is saying. The engineer, they knew very well and well in advance that the technical floors aluminium had been omitted. What you said earlier. They said it. And they actually said that the engineer had cancelled it way before.
When you
Do
say
you recall
cancel
that?
I can't remember the full description of the narrative. I remember something of that nature.
But what 5 said in their defense, it's what you just said. That it was the technical floors aluminium. And Mr. Akiki, in his witness statement, produced these documents. And these documents produced the engineer's notices. To make a long story short, we can show them on screen if you want.
Please.
But it's only the date that matters, not the content, because we don't dispute the content. For me, what is important is the date, and it is undisputed. It's a very long document. I'm happy to, very big document, happy to project it, but I don't think that anyone disagrees about the dates.
Would it be helpful to give me a summary of what that document says?
I put to you, and let's pretend for now that I am accurate. My colleague will correct me during re-examination if I'm not accurate, that the first document, whatever it was, that omitted these words was issued on 28 March 2017. If you can please take note of it. Thank you very much. The second, which was dated 3 January 2018, it was received, stamped as received by the main contractor on 19 April 2018. Let's take the second date, the latest date, 19 April 2018. And the third relevant document issued by the engineer was received by the contractor on 19 April 2018. So, you will notice that these documents, these omissions were made after the works order was issued, but before the signing of the contract. We established, we agreed, the contract was signed on the 4th of June.
Based on these dates you've given, yes.
Yes. So, the engineer knew about, had made the omissions. 5, he knew about it. I can't believe that the engineer acted, omitted from the technical flaws without telling 5. I think it's common sense. 5 knew. This happened in April, yes?
2018.
Yes. And then 2 months after, a month and a half after, to be precise, they signed the contract for 47 million again. I.e., at the time that they agreed to a contract price of 47 million, they knew, both parties, 5 definitely knew, that these works, that 3 million works, not 30,000, not 300,000, 5% more of the overall contract price of the original, of the 2016 contract price, had been omitted, but they kept the same number, the same figure, 47 million. Do you see what my reasoning is, Mr. Law?
I see where you're getting to. You want me to reply?
And I'm eager to hear what you have to say. Do you still insist that the engineer had a right to deduct?
Well, let me put it this way. We are very clear that in Mr. Paul Craig and in your pleadings, that in the descoping of the works, you accepted the fact that you want to deduct the abortive works for the design at 5%, and I think 9%, if I stand corrected, 9% for the overheads and profits for abortive works, right? Now, during the course, I mean, obviously, I'm only explaining based on my detective work and assessment as a architect, project manager, and so forth. It is possible, yes, the engineer is aware in the design that levels 18, 19, 39, and 40 are service floors. But he was not aware, perhaps, until during the production of the design work and the production of the shop drawings, that he realized that Reem have included a typical layout of all these louvers and so forth in the scope of works, which was not necessary for the service floors, which is why that is the case, you know.
Mr. Law, you go into a dangerous path here, allow me to say. Leaving aside that it is, I'm talking about instructions, 3 million worth instructions, a month and a half before signing the contract. A month and a half, not 2 years ago. Mr. Nabil yesterday was outraged when there was an issue whether shop drawings were being designed or still being executed until so late. He was adamant, and it's on record. So there's a transcript for this. Shop drawings had finished much, much earlier. And it doesn't matter in reality. That's my point is that all this is irrelevant. Can we at least agree that when the parties entered into the contract in June 2018, they knew that 3 million worth of work would not be required? Can we agree on this?
Well, based on what you say, the evidence on this document, I mean, this seems to be the case.
Based on this, we agree. Excellent. Can I have the work order, please? That's all I have from Mr. Law, Your Honor. I'm done.
Thank you very much, Mr. Costello. Just because the cross-examination was finished earlier than you might have expected, I think we're still sticking to the 10 minutes or so for re-examination.
Yes.
I cannot hear you, Your Honor. There was a lot of background noise for some reason.
I was simply saying to Mr. Costello that even though you had been quicker than perhaps was expected, it did not mean that he had longer for re-examination than the 10 minutes or so that we agreed.
Thank you very much, Your Honor. Appreciate it.
Because we have other witnesses to go through.
Yeah.
Yes, Mr. Costello.
Yes, Mr. Lowe, you were asked many questions about Mr. Akiki's delay analysis, you will recall.
Yes.
And you have been taken to your report.
Excuse me, Your Honor. This time I have to protest in time and not allow 1.5 hours of re-examination again. I asked very specific questions, and I would really appreciate if my colleague sticks to my very specific questions, which I noted one by one. Apologies again for the interruption.
If he goes beyond the proper scope of re-examination, then you can put your hand up and you can deal with it on a case-by-case basis. Mr. Costello.
Thank you. You were asked many questions by my learned friend about Mr. Akiki's delay analysis, and you were referred to paragraphs 8.31 of your report, and specifically on the wording, the use of simple illustration.
Yes.
Do you recall that? Just
Yes.
explain what exactly you meant by simple illustration.
Basically, as I say, and Mr. Nabil has already admitted, in the respect, not admitted, but clarified with Mr. Cavallis, that it's not follow any professional protocol used by a planning programmer in that respect. It's just an illustration, a clear illustration, a simplistic, simple for anybody to understand. And as he said, it was the benefit of the judge and the court, instead of a complicated planner's program. This is how I mean by the simple illustration.
Yeah. And I think in one of your answers, you referred to as planned, as built dates. Let me start again. One of your answers, you referred to if the as planned, as built dates provided are substantiated, that would assist. Now, just explain what that means in very simple terms.
Well, basically, it's been well documented and presented by Mr. Lee Spoley, and as planned is exactly as what Mr. Nabil has done in the first part, and as built is in the second part of the diagram. So if this information was there, if there was a program, which there was none, produced by focusing on Reem's work, that would support basically what Mr. Nabil has done, but there is no record of that. Does it help, or is that not clear?
Yeah, no, that makes sense. Just so I understand, then does it also work the other way around for Reem's delays?
Yes, because, as I said, I have the benefit of reviewing all the documents after my report. That, as Mr. Lisboli said, there's no as-built plan, and there's basically no records whatsoever to record the delays of any party. But there is evidence of the fact that after the 15th of March, based on Mr. Akiki's analysis here, it's basically, as I mentioned earlier, this is the point taken at level 59. They were all delays. This is where Reem's delay should finish, if there were anything in terms of the scope of work they have to determine as level 59. And anything after 15th of March 2019, as I comment in my report, as Mr. Cavallis directed me, is that yes, all the other issues were delayed by Reem up to the 2nd of September.
In relation to the descoping of works, cancellation, omissions, these are all the same words for the same, meaning the same thing. Yes?
Yes.
Now, you were asked about what is essentially the Reem's claim for the descoped works. As far as, correct me if I'm wrong, the abortive works that you referred to, these are the design works. Is that right?
Yes. Correct.
And I know you've had the privilege of reading Mr. Craig's report as well, who confirms the same. Your opinion that you had given, which you've answered as well in one of the answers to my learned friend, is that the engineer was entitled to make a deduction in accordance with FIDIC or the subcontract agreement, I think you said.
In accordance with the subcontract agreement, SCA, yes, because it says that very clearly.
Now,
I can't remember the clause number, but it stated very clearly.
Now, is there, in actual fact, any significance in the fact that the subcontract agreement is signed after, in June 2018, with the fact that the parties have been engaging in work in pursuance of the work order and clearly have a relationship of some sorts?
Yeah, there's no relevance because at the end of the day, all parties there is what happens after, in terms of identifying any particular deviations from the scope of works or the program for that matter. I think at the end of the day, I recall on another circumstances, maybe I'm not allowed to answer. I noticed for example, the first extension of time claimed by Reem in October 2017, which was not taken into account at the CA. So it works both ways. Both parties have that situation. Reem was aware that according to the extension of time in October.
Mr. Cavallis, I think, is objecting.
Okay.
Okay, I think he stopped. Okay. Yes, the point here is that the point that was being made with you in cross-examination, and I want to spell it out because I want to make sure I'm right in my understanding, is that the subcontract agreement is signed in June 2018. The right to descope is enshrined in June 2018. And
correct.
Descoping took place before June 2018. That's essentially the point that was being made to you. Was that your understanding as well?
Yes, that's right.
Now, as you were just making giving an example now, there are times where parties may act in a way which gives rise to, say, a FIDIC right. For example, an EOT, they can make a claim for an extension of time, which is a FIDIC concept as well.
Yes, correct.
But there may not be an agreement, a contract, but still a party may make a claim for an extension of time.
Yes, of course.
And in the same way, a party may descope or cancel or omit works when there isn't a subcontract agreement.
Yes.
So does it come to this, that the significance of the date of the agreement in the context of this case is redundant?
Correct.
Thank you, my lord. I don't have any questions, any further questions. Do you have any questions for my witness?
I'm tempted, but no, thank you.
I'll be happy to, my lord, if you give me the option.
Thank you very much. Thank you, Mr. Doe. That's the end of your evidence. It's quicker than expected, by me at least. But thank you. You're free to go now.
Thank you, my lord.
Thank you very much.
My lord, I wonder if we can have the break a bit earlier, just so I can have a quick phone call with Mr. Lowe, because we're about to get into my learned friend's expert evidence.
Yes, the idea was the 10-minute break would be at the end of each witness. So
Yes.
let's it's now 9:28. Make it 9:40. We resume. Happy with that? Yes.
Your Honor, if I may, sorry, I cannot stand up so that you see that I'd like to take.
I can see you.
That's why.
Sometimes.
I wonder if it would be now an opportunity to address the housekeeping issue that I mentioned earlier.
Okay. Happy with that, Mr. Costello?
Yes, I am. I don't know what's about to be said, so I may have to reserve my position in terms of coming back, but yes.
Let's start off and see. Yes.
Yes, no. Yeah. Admittedly, I did not have time to notify my learned friend because just found out late yesterday and this morning. We are of the view that the re-examination of Mr. Akiki went way beyond what it is it would be expected. I don't have the benefit of the transcripts, but it seems to me that examination in chief and re-examination was more than 2 hours, perhaps even more. But anyway, this is not so much the time. Mr. Akiki, in his re-examination, made several comments which are not only contradicting his testimonies written in writing and oral, but also my client is adamant that they are utter false. He made statements that are entirely false, knowingly false. And he made these comments with the benefit of hearing Mr. Ahmadi first, because unfortunately we had to change the order. Irregularly, Mr. Akiki was not available to continue his cross-examination the day immediately after it was interrupted, as one would expect. So when he came back, he did have the benefit of knowing Mr. Ahmadi's testimony, and actually reserved those statements for the re-examination stage. It was more or less obvious what the re-examination would be about, considering my questions. Therefore, it would only be fair if Mr. Ahmadi is allowed to appear again before you for the benefit of the court, not just the defendant, and we are the defendant here, for a short further examination, which can be, I don't propose to upset the schedule, not at all. It can be Friday after the examination of the two forensic accountants.
Right. What do you say? It would be helpful when I'm considering this to know what you say went beyond the proper scope of re-examination.
Primarily the process, and I made the point actually during this, when my friend brought this famous photograph to the attention of Mr. Akiki. I think they spent yes, the photograph with of the outside of the building, yeah. This blue yeah. Photograph, you recall. I think they devoted half hour on this. Mr. Akiki described a process which was, first of all, not outside the ambit of the cross-examination, but this is not important, perhaps so much. Described a process of works, which is, as my client insists, entirely contradicts entirely what actually happens on site. Entirely. He presented a false picture of what was the sequence of works. Mr. Ahmadi is adamant on this. I am obliged to bring this to your attention and request your permission for Mr. Ahmadi to appear before the court. He will be, of course, subject to questioning by my colleague. I know that it is not the most regular request, but unfortunately, in the way this case has transpired, not many things have happened in a very regular manner. And I don't think Reem can be blamed for this. This is our request, Your Honor.
Right, what I'm going to do is allow Mr. Costello to consider the application, and we can discuss it further when he's had a chance to consider it, and maybe after the next witness. All right?
Yes, thank you very much.
Now, it's now 25 to. Do you want to resume at 1:45?
Yes.
Can we make it 10 to the hour, Your Honor, if you don't mind? 15 minutes instead of 10.
Sorry?
To have a 15 instead of 10 minutes break, Your Honor, if you don't mind.
I suppose we've earned it by being shorter with this witness. So, will the next witness be the same sort of time?
Probably. Yeah, sorry. Probably around the same sort of time.
Yeah. Okay. Well, let's resume that. If you're happy, Mr. Costello, at 9:50. It's 12:50.
Yes, thank you.
Thank you.
Thank you very much.
Thank you.
Your Honor.
I can't see you.
Can we switch on the camera? Sorry, I thought I thought the camera was on. One clarification. Can you hear me now? Can you see me?
Yes.
Just one clarification to be more precise about my earlier application. The documents that I mean are on the occasion of the re-examination of Mr. Akiki about this photograph that I explained, there were certain drawings that were shown to Mr. Akiki, which came up only during the re-examination of Mr. Akiki, not before. And this is what triggered the request of my client, of the defendant.
Yes, and you would be wanting to ask questions about those drawings.
Yes, and the questions will be about those drawings and what they really show and what really happened. It's not. I don't think it will take more than 15-20 minutes max.
Okay, well, Mr. Costello has heard that, and we'll come back to that question. If you can give me the references in due course, not now, but if you can make a note of the references for me to the drawings.
I will.
Otherwise, I have to go back through my notes. Okay. We're ready for Mr. Sporley.
I believe we are, yes. There he is.
Good morning or afternoon, wherever you are, Mr. Sporley.
Afternoon for me.
Right, we'll stick to the same, Mr. Emirates will stick to the same principle of about no more than about 5 minutes in chief, and then more than about up to 10 minutes in re-examination, 2 hours altogether. Mr. Sporley, the court staff will administer the oath for you. Thank you.
Okay.
Good afternoon, Mr. Sporley.
Hi.
Could you please state your full name and occupation for the record, please?
My name's Lee Spall. I work for GMCS and I'm a delay forensic planner.
Thank you. Could you please confirm if you're taking an oath or an affirmation today?
Affirmation, please.
Thank you. Could you please repeat the following statement after me? I solemnly declare and affirm
I solemnly declare and affirm
that the evidence I shall give
that the evidence I shall give
will be the truth, the whole truth, and nothing but the truth.
will be the truth, the whole truth.
Thank you.
We lost you for a moment, Mr. Sporley.
Sorry.
I think your microphone went off. Could you repeat just the last part? Will be the truth, the whole truth, and nothing but the truth.
Will be the truth, the whole truth, and nothing but the truth.
Thank
Thank
you.
you.
Mr. Carveles.
Thank you, Your Honor. Just to confirm, Mr. Sporley, you issued one expert report,
Yes.
which is dated 19th April 2022.
Yes.
It is found at page G for golf 1674, Your Honor.
Yes, I have it. Thank you.
And it goes all the way to page G1733. Your report, and you confirm that this is your report.
Yes.
Mrs. Sporley, very few questions from me. The first question is, have you looked at all the documents that are on record on this trial, including both parties' pleadings and exhibits?
Yes, I have.
And you have taken them all in consideration. Am I correct?
Yeah. Yes, I have.
We have discussed, and you are. I understand your background is that you do delay analysis for a living.
Yes.
Correct.
Yes.
And have you done any such work for Reem Emirates Aluminium before, or is it the first time?
This is the first time.
Right. Now we looked at several documents. One of them is a document which was exhibited by Mr. Nabil Akiki, the sole factual witness and CEO of the claimant, which he calls delay analysis. Do you know what I'm referring to?
Yes, I do.
If you don't have it in front of you, it's at E10994. I can show it to you. Have you looked at it? Have you considered it?
Yes, I have.
Do you consider it a delay analysis in the first place?
No.
Why not?
Because it's more, it is a, I think Mr. Lowe put it very good. It's a simple illustration showing dates that have been selectively picked out of a master program. There is no critical path analysis produced on that simple illustration.
Does it, the work of Mr. Akiki, does it show the actual situation on site, both between his as planned as built dates and primarily until the end of the works?
No, that simple illustration says that level 59 should have finished by the 15th of March, and it didn't finish until the 2nd of September.
You've seen the evidence, and I think you watched the examination because of factual witnesses on the basis of the evidence that you have in front of you. Are you convinced that there were delay events after there were works, first of all, after the 3rd of March in relation to Eaves? Were Eaves, roof garden Eaves works completed on 3rd of March, as Mr. Akiki argues?
There's been evidence I've seen that show, my report also says that there was Eaves work continuing after and access after the 3rd of March.
And I think we can agree that the works roof garden Eaves completion factual date 3 March 2019 mean that all works, all Eaves related works were completed on 3rd March.
The simple illustration indicates that.
Yes. And that's the natural reading of this words. Now, have you read Mr. Law's report?
Yes.
And I understand you have met with Mr. Law, correct?
Yes, on one occasion. We had a team's
On
meeting.
one occasion. In relation, well, Mr. Law covered both delay and quantum. I will only ask about the delay part. In your opinion, did Mr. Law investigate? Is it my understanding correct that what Mr. Law is saying is that he supports and relies on Mr. Akiki's analysis that Reem was the sole cause of delays? Is this what Mr. Law is saying?
Mr. Lowe hasn't produced his own analysis. He said that he's relied on Mr. Akiki's illustration.
And do you have any indication that Mr. Law investigated Mr. Akiki's analysis?
Only that he said that he agrees with the dates used, but that's it. That's all I know.
Do you consider that you have indeed investigated Mr. Akiki's analysis?
I've investigated the information that has been made available to me, and some of that is used in Mr. Akiki's analysis.
And your investigation covers the entire period until the hotel opening, 2nd of September.
To the 2nd of September, yes.
Thank you, Mr. Spall. No further questions, Your Honor.
Thank you, Mr. Costello.
Mr. Spawley, I want to just clarify, because I think it may not matter too much, but I think we need to be just clear. The documents you relied upon, page 1678 of the bundle, G1678, sorry, is your page 5 of 60.
Yeah.
I think let's just be clear about this. You looked at the pleadings dated 20 A and B and D, yes?
Yes.
And these are what I'm going to call the 009-2020 claims. And you looked at the respondent statement counterclaim dated 3rd of February 2021. Yeah?
Yes.
But not the amended counterclaim. Is that right?
I can't recall.
No. Well, it would be there, wouldn't it, if you'd looked at it?
Yes. Yes.
Okay. And you also didn't look at the amended defense to the counterclaim. Correct?
Correct.
And you didn't even look at the original defense to the counterclaim, correct?
Yes.
Okay. So let's just be clear on what you have looked at then. Now, these documents, were provided to you, or did you seek them? Did you ask for them, or were they provided to you?
Some documents were given to me, some documents I asked for.
Okay. And in terms of you were assisted, weren't you? I'm not criticizing the fact you were assisted, but it's just a fact. You were assisted in the
No, I
production.
was assisted, yes.
And in terms of your assistant, we don't know much about him other than what's said. But in terms of exactly what he did,
Yes.
Is he the one who put the information in that he inputted the data and then you looked at the final product to give your opinion?
No, I asked him to review programs,
right,
and pull out and do the checks on programs.
Okay, but you would have reviewed his work as well, I presume.
Oh yes.
And in terms of your analysis, because we can split it into two parts. You analysed what I'm going to say the respondents. You call it a respondent, but we mean Reem. Reem's case, and you analysed Five's case, correct?
Yes.
And obviously, I appreciate you've taken some facts as simply assumed, which I'm not. I've got no issues with. But what we do understand is that you looked at a delay analysis dated the 30th of October 2019 from Mr. Akiki, correct?
Yes.
That's at paragraph 44 of your report. That was a previous delay analysis by Mr. Akiki. Is that right?
Yeah, there was two produced.
Yeah. Because you may remember some questions being asked yesterday about NA. I'm calling it NA31, but it's the delay analysis we've seen put up on screen many times, and whether or not when it was prepared. But I think it's right to say that Mr. Akiki did actually prepare a delay analysis in October 2019, 30th of October 2019.
Yeah.
And I think maybe another one 8th of March, but that may have been the same. But certainly you've also looked at the updated one, because that's the one that claims 170 days, although you say it's 171. But anyway, 1 day's difference is not a big deal. Yeah. So we're agreed so far?
Yes.
Okay. Now, on the information in terms of the defendants, the information that you had from the defendant, it's right to say you saw an extension of time claim, which we're calling the first interim extension of time claim, from Reem. Is that right?
Yeah, EOT number 1 was that October submission and November submission.
I think it was November 2017, but
EOT 1 as I know it. Yeah, I've seen.
Yes, exactly. You also made the point that at paragraph 144.
Yep.
That the second extension of time prepared by the respondent, i.e. defendant, was not issued during the contract and is included as part of the respondent's standard disclosure. Yes. So
yes.
This second extension of time is the one that you may have heard reference to before as the December 2020 claim. Okay. Is that right?
Yes. Yes.
So I appreciate you may have. Did you look at that at all, or are you just aware of that?
I have looked at it because I think I've mentioned it in my report of what it claims. I believe.
Yeah. Okay. But in terms of the your analysis, you focused on the EOT1 claim. Is that right?
No, I didn't focus on the EOT1 claim. I focused on the period of delay that was put forward. Yeah, 170 days.
Yes, but you did look at
I looked at the EOT1. Yes.
Yes, you looked at the EOT1 and you gave some comments. No, is that right? I
did give comments on the EOT1. I gave comments on EOT2 as well, I believe.
Yes, but in terms of your, you've said at paragraph 151 that the respondent demonstrates no as-built critical path in his EOT submission.
Correct.
Which one is that, or both? Which one?
That would be both.
Right. So you're saying neither has demonstrated an as-built critical path. And as far as you're aware, there has not been an EOT submitted before, other than EOT 1, before the engineer's determination, correct?
My understanding, correct, yes.
And you're familiar with the FIDIC rules, aren't you?
Depends which one you want to pull me on. I'm not an expert on that.
I'm not going to take you by surprise then, but I just wanted to understand, do you have any familiarity with it, with FIDIC?
We have some familiarity, yes.
Okay, so in terms of the bundle, and I don't know if you've got it in front of you, if I need to show you, then let me know.
We would have to,
Say that again, sorry.
don't have access to the bundle.
Okay, I'll put it on the screen. The page reference is G for golf, 1364. And Mr. Spaulding, I'm sure you'll bear with me. You've seen I've had some IT issues over the past few days, but I'll do my best. So this is the conditions of contract for construction for building and engineering works designed by the employer.
Yeah.
And there's no issue about this. The parties agreed this is the correct version of FIDIC. Now, I presume you have some familiarity with clause 8 because that deals with extension of time.
Yes.
And in particular 8.4. I'm just waiting for it to load. So this deals with the extension of time for completion.
Yes.
See that?
Yes.
Where it says the contractor, so that would be Reem, shall be entitled, subject to clause 20.1, so that means we need to look at 20.1, to an extension of time for completion, if and to the extent that completion for the purposes of 10.1, which is the taking over of the works, is or will be delayed, and there are a number of causes out from A to E. A variation could be one. A cause of delay could be another. I don't think there's any suggestion that climatic conditions here were an issue, or D, unforeseeable shortages caused by epidemic or governmental actions. But E is certainly something that Reem is suggesting is engaged. So it's potentially A, B, and E, potentially.
Okay.
Now, if the contractor considers himself to be entitled to an EOT, the contractor shall give notice to the engineer in accordance with 20.1. So we got 20.1 back again. Yep.
Yep.
So it's quite a significant clause that we need to look at. So let's look at 20.1. If the contractor considers him, this is 20.1, page G1437. If the contractor considers himself to be entitled to an EOT and or additional payment, etc., we can summarize this. The contractor shall give notice to the engineer describing the event or circumstance giving rise to the claim. The notice shall be given as soon as practicable and not later than 28 days after the contractor became aware or should have become aware of the event or circumstance. Yes? You see that?
Yes.
And then there are some other particulars given on the engineer on the failure to provide a notice. Then extension of time shall not be extended, and the contractor shall not be entitled to additional payment, etc., etc.
Yes.
You're familiar with this clause, yes?
Yes.
Yeah. So, and then we've got here, within 42 days after the contractor became aware or should have become aware of the event or circumstance giving rise to the claim, or within such other period as may be proposed by the contractor and approved by the engineer, the contractor shall send to the engineer fully detailed claim, which includes full supporting particulars of the basis of the claim and of the extension of time and or additional payment claimed. Yep.
Yep.
Then if the event or circumstance give rise to the claim has a continuing effect, this fully detailed claim shall be considered as interim like the EOT1 submission, yes?
Sure, yes,
And the contractor shall send further interim claims at monthly intervals, etc., and a final claim within 28 days after the end of the effects resulting from the event or circumstance. Yep.
yes,
Okay, let me just take that off screen for a moment. So what we have in terms of the timeline is we've got the fire incident, 6th of August 2016. We've got addendum number 1, do you agree? It gives a revised completion date of the 25th of October 2018.
yes,
Okay, so with July 2017, number of months later, in November of 2017, EOT1, which asks for a completion date of, unless I'm
March
mistaken,
9.
I think it's, yeah, March 19. I can't remember the exact date, but we'll stick with March 19. And then after that, we've got the subcontract agreement. And you've seen clause 4.5, I believe, of that agreement,
yes,
where the agreement is to follow according to the revised baseline program, which is as per addendum number 1, agreed?
yes,
So that means the parties set that the completion date is the 25th of October 2018, as agreed between the parties.
yes,
And after that date, arguably, FIDIC is engaged 28 days and the 42 days, etc. Do you accept that?
yes,
And there is no EOT claim made after the subcontract agreement was signed.
not that I've seen, no.
I ask you to look at, it's your page 17 of 60. If you bear with me, I'll read out the bundle page reference. Just hold on one moment. Okay, so G1690, you have that in front of you, yes?
I've got my report in front of me.
Thank you. In terms of the stages, does it come to this, that what you're saying is the works go up? So starting from 6 to 17, etc., and then at the end, when we get to stage E, is the very top concluded as well as the very bottom?
Yes, that was taken from the program of works.
Yeah. From addendum 1.
Yes, the revised
Yes.
program with the 25th of October completion.
Good. And we've got, I think on the following page, we've got the wings as we looked at yesterday with Mr. Kiki, wings A,
Yes.
B, C, and we've seen, and you have certainly seen the WIR that Mr. Kiki relies upon in terms of the eaves works, where it mentions A, B, and C.
Yes,
And it's just these 3 wings at level 59, is that right? And other floors, but I'm just asking.
yes,
Now, we saw in terms of the eaves, and I don't know if you need to see it again, but we looked at the WIR yesterday on the eaves, and you remember the 3rd of March date, and you'll recall, I hope, that the comment that was given that the client approved these works. Do you remember that evidence?
yeah. What was the approval again on that? Did you say?
It was it said something like the client approves the works.
Okay, but was that the one that said D for information?
I'll tell you what. Yes, I think so. But I'll tell you what. Just to be, I'm pretty sure it did. But I'm just going to show it on screen just to be clear. Just hold on one moment. Yeah, so this is page E for Echo 1102. I'll see if I can zoom in. We can see here the inspection date request is the 27th of February and the inspection date itself is 28th of February 2019.
Yeah.
We've got all three zones are covered on this floor.
Yeah.
Yeah. Yes, you agree?
Yeah, it says A, B, and C. It's just it mentions some grid lines there.
Okay.
So I'm just not clear whether that's all the grid lines, the entire building, the entire floor, or just parts within A, B, and C, because it specifies grid lines.
Mm-hmm.
That's my only concern with that document. I'm not clear on whether it covers the entire floor 59.
Help
Right.
me where it says grid lines.
My lord, under the work element to be inspected, where there is the handwritten note of render instead of paint, it says at zone grid T12 to 2, and then zone B grid 8 to 10, then zone C grid 4 to 6. So it's referring to specific grid lines on that. It doesn't just say the entire ABC. And I'm not familiar with all the grid lines, so I apologize.
Okay. And what I was asking you to look at was, however, this work inspected and accepted and approved by the client, and code D is ticked here.
Yes, I can see that.
Dated 3rd of March. Yep.
Yeah, I can see that.
Yeah, okay, fine. Let me just close this. Now, I think it was 4.14. Let's look at 4.14 of your report. That page G1698.
Yes.
Yeah.
You say at paragraph, in fact, paragraph 102, you make the point about the logic. The logic is used, provided an unreliable critical path. Can I just try and understand this in simple terms? In terms of, this is a case where we've got 7,236 activities.
Yes.
Yep. And you have looked at the data, as you've said, not just the baseline programs, but the weekly reports, the daily reports, etc. And you have concluded already that the EOTs, both plural, don't demonstrate a reliable as planned, as built critical path delay analysis, correct? Oh, you can't, yeah.
Yes.
Sorry, the as built. And your opinion on the baseline program is also that the logic that has been used doesn't provide provides an unreliable critical path, correct?
Yes, through the software itself. Yeah.
Through the software itself. Now, when you looked at the program progress updates,
yeah,
and it might be easier if we look at the table that follows paragraph 107.
Yeah.
Just so we I think it's just the following page, G1699.
Right.
So you compared the daily report activities with the weekly progress updates.
Yes.
And the daily report activity, you looked at it, is it right, as of 13th of March 2019?
Yes.
So the dates we find I'm calling the first half of the table,
okay,
are from as they were inputted as of the third, or no later than the 13th of March 2019.
Yes.
And the section which says weekly progress update is as of the 29th of August 2019.
Yes.
Now you made comparisons and you found what we're going to call anomalies.
Yes.
Is that a technical term, or is it just what it means? It's just there's something that doesn't add up.
It's a discrepancy between the dates. Someone's put a date in one file and a date in another file, and they don't match.
Now these are, yeah. Sorry, no, you carry on. You carry on.
No, so it's purely there's an anomaly between the dates. There's a discrepancy, and one of them is an error, but which one, I don't know.
Yeah, fine. But certainly what you have noticed is that, for example, this is the first one. We can see the anomalies in highlights. Curtain wall aluminium frame installation. actual finish date was noted as, or the data that was inputted was the 7th of April 2018, but the actual finish was the 1st of April 2018, as noted in the weekly progress report.
That's what it says.
Yeah, and you notice there's clearly one can't be right. Neither can be right. One of them is right. Which one, you don't know.
No.
Now, these are Reem's. These dates come from Reem's documents, correct?
Yes.
And these, the ones you've highlighted, are these just examples?
That's just some of the examples we found.
So there could have been a lot more.
Yes.
Do you know how many more?
I can't recall how many more there were. There was. I mean, that was just one level. That was just level 32.
This is just level 32, but for example, for level, you didn't choose level 59.
I hadn't chosen, no.
But you knew the delay analysis looked at level 59 from Mr. Akiki.
Yes.
So why didn't you look at level 59?
Because I'd started this process before level 59, and level 59, for me, I just wanted to assess where the delays were. So I randomly chose a floor to look at that floor.
Okay, but you could have also then, let's just go along with that. You chose 32. Okay. You could have then gone back and looked at level 59.
I could have done, and I would have had anomalies probably on that.
But we now can't see the anomalies because you haven't tabulated it.
Okay, I don't understand why that would make a difference, because I've said that the progress updates are unreliable. I haven't said level 59 is reliable and 32 is not. I've said the progress updates are unreliable.
Yeah.
So that would affect every single floor. That would affect 59 as well, no doubt.
Yeah, but we won't be able to now, we haven't now seen the actual dates. Whether it's wrong or right, some of these are clearly, not every single one of these are inaccurate. So for example, roof garden, installation of sliding door frames, 9th of May, that's the 9th of May as an actual start date. But there are dates missing. But I presume that there were other activities, for example, where you don't have two different dates. You just have a missing date and an inputted date. Correct?
Yes, it could be either one of those. There's a number of factors that can affect the progress updates. It's very rare I find any progress update correct.
Yeah. Okay. But what you ultimately had to do is that you had to look at other pieces of sources of information, let's call it. For example, the WIRs and text messages and et cetera, et cetera.
I was trying to form an as-built by looking at the actual data. The progress data wasn't reliable to give me an as-built program.
Yeah.
So I looked at other sources that would have been mutually agreeable between the parties that could be relied upon.
So
to produce an as-built.
yeah, I don't disagree with your why you've looked at it. I'm just getting to the conclusion of ultimately you had to look at other sources of information. I have questioned why you didn't look at level 59. We've already had your answers on that, but just so we're clear, I'm suggesting to you, just like you did, Mr. Akiki tried his best to try and put together some sort of analysis.
That's the question.
Yeah.
The witness can't answer questions about what Mr. Akiki intended.
So yeah,
Can I just interrupt just for clarification? Mr. Spall, 2 or 3 times in your recent answers, you said the progress updates were not reliable.
Correct.
But I'm not sure whether you're highlighting the progress update as opposed to the daily report activities being unreliable, or whether you're saying that there's simply a mismatch and therefore the two of them can't be relied on.
There was a mismatch between them. The daily report activities recorded would probably take a priority over the program, but there wasn't sufficient evidence to support that daily report date as well.
I see. Thank you. Sorry to interrupt.
That's right. Yeah, as we were getting to it, you looked at other sources of information, which started off with the WIRs, and then we looked at, I think you looked at handover documents, closeout, WhatsApps, etc.
Yes.
The WIRs is the only source of information that you have that we can look at which predates March 2019. So let me put it another way. The WIRs is a log of the work inspection requests that were inputted by Reem between 2016, unless I'm mistaken, 2016 throughout until 30th of April 2019.
Yeah, I'm not sure how far they go back, but the WIs I would expect would start from the first pass to work.
Yeah. Whereas, for example, the WhatsApp messages are clearly limited in time to whatever they show. The handover documents are from post-date 8 March 2019, and the closeout again similarly post-dates March 2019, as does the variation order itself.
Yeah, I focused on that period of time.
Yeah, fair enough. Does it follow then as well that in the absence of an as-planned, as-built, and critical path, the delay notifications that was submitted by either the engineer or, in fact, Reem cannot be objectively substantiated?
Oh, I can't. I don't need to see those notifications to see what they say.
But do you agree they can't be objectively substantiated?
No, I can't say that. I haven't seen what the document attached to those notifications are. It could be a different source of material that I've not seen. I can't say what was submitted and whether it was good or bad.
I'm asking the principle.
Sorry.
I'm asking in principle. I'm not asking you whether you looked at a delay notification and you were able to substantiate or not. I'm just asking, because we don't have an as-planned, as-built, no one can objectively substantiate the delay notifications.
I can't answer that. I'm sorry.
Okay. All right. So let's move on to the WIRs. We've looked at this. I believe yesterday or the day before. Just bear with me. Try and get it up. Yeah. I'll get it up on screen. This is. I'll give you, Manol, I'll give a page reference. It's G for Golf 2952. Let me just sort the dates out. Yeah, so the earliest date we've got in terms of the WIRs is December 2016.
Okay.
As you can see and confirm, correct?
Yes.
Obviously, this isn't the actual WIR itself, it's just a log.
Yes.
Yeah. Which Mr. Almaty confirmed he inputted. And it says here, as of 30th of June 2022.
Yes.
Just out of interest, if work is done after the 30th of June, it should be logged, correct?
The work inspection request should go right the way through to the end of the project.
I'm sorry, I didn't hear any of that.
Work inspection request should continue until 100% of the works are completed.
Okay, fine. And I'll sort the date to go from the latest. I should say we've got regularization inspections, but after the 30th of April, we don't have any other work inspection. There are no other work inspection requests, correct?
Yes. Work inspection requests, there were some, I believe.
I'm only going by, yeah, go on.
I'm just going from a report. I've got 6 that are on the 1st of May work inspection requests. It's only a day out, but our date of inspection first. Date of inspection 1st of May. Yes, correct. Yes.
Yeah, well, a day out. Yeah. Fine. I'll give you that.
Yeah, no, it's fine. On the log, the date inspection column is the 1st of May.
Yeah, you're talking about the inspection date as opposed to the request date.
Yes.
Yeah, okay, fine. Because it's the inspection date that has some significance as well. The significance of the request date is that's the date the request is made by the contractor.
Yes.
Doesn't mean the works were done on that date, of course. They could have been done 2 months before, 3 months before, who knows when.
Yes.
But the inspection date, if, for example, work is approved, that's the date that the works are deemed approved.
Yeah. Or rejected, or
Rejected, or
Yep.
etc. It's important. Would you agree that if works are being done, that the work inspection request is submitted as the works are being completed?
That's the ideal situation. Yes.
Yeah. Because that would also not only reflect when the works are done, but hopefully the engineer would come and inspect the works and approve them, or if needs be, reject, to make a determination on them within around the same time.
That is the ideal situation. Yes.
So taking the 30th of April as just one example, we've got a number of WIRs submitted.
Yep.
I haven't counted them, but I don't think I need to make the point. There are a number of WIRs submitted on the 30th of April and inspected on the 1st of May. We can see that, yeah?
Yes.
We've got one on the 22nd, and a couple on the 16th of April. But again, the 15th of April, we've got another batch.
Yeah.
Covering various floors. One on the 14th, another batch on the 9th of April, another batch on the 6th of April, 31st of March, and so on and so forth. We don't need to look through every single one, but I think you'll agree, wouldn't you, that it seems that works are being done to various floors and wings, and then they're being submitted at the same time in a batch.
Submitted in a batch, yes, but not necessarily at the same time the work was carried out.
That's what that's what I was trying to say. That the works are being done. Works are being done. For example, let's just take this example. 52 here.
Yeah.
We've got hinge door installation. Again, 52 balustrade glass installation, and on level 53, a different floor, we've got sliding shutter, stick curtain wall, glass, etc. Doesn't mean they're all being done at the same time, but what I'm saying is work is being done to these floors and then submitted all on the same date. Is that agreed?
That's an option, yes.
Mr. Condell, I suspect the difficulty is in your language. The work is being done as opposed to the work has been done.
Yes, fair enough. Work has been done to these various floors and wings at a time. Yes. We don't know when.
No.
But the submission date of the WIR, they're being bundled together. So various floors are being batched and bundled together.
Yes. Okay. Yes.
Might that be an indication of a subcontractor being in delay in carrying out its works? And that's why, for example, Reem is doing a bunch of works and then submitting a bunch at the same time.
No, I can't. I can't agree with that assessment. I can't agree with that assessment.
Okay, but you can't. Am I right that you can't necessarily disagree?
I mean that may be a situation,
right.
And it may not be a situation.
Okay. The last submission we have on level 22, you made this point, is on the 30th of April 2019 with the inspection date of the 1st of May.
Yes.
That's level 22. I'm just going to have a look at level 59. So we've got balustrade glass installation, all three wings are covered here. And the submission date is the 2nd of March with the inspection date of the 5th of March. And it's been given an E, resubmit.
Yes.
Now, we've got A means approved, B means approved as noted. If it's not an A or or a B, it's not approved unless, for example, the client accepts the works.
Correct. We saw that with the D. Yeah.
Yeah, as an example, that I think, yeah, with the eaves. But what we've got here is that we're looking at the logs. This is all
Yes.
we've got to look at.
Yes.
And we've got level 59 here, 2nd of March, balustrade glass installation. And then and before that, for the same works, seemingly to the same wings, a submission of the 27th of December 2018 with an inspection on 29th of December 2018 with an E.
Yes.
Which indicates it's not approved, correct?
What we've heard this week is that sometimes that was because they wanted to approve the whole area. That was put forward. Yeah. I haven't seen what the E means myself.
Yeah, you haven't seen the WIR.
Yeah. But okay, is E approved under that coding? No, it's not.
Okay, that's what I wanted to get at. Just bear with me. I'm just going to switch around some documents. There's the handover. We've looked at the handover documents earlier in the week, and if you just bear with me one moment. Yeah, it starts on G for golf 2929. So this is a document that you looked at. These are documents, I should say, you looked at. And we've got various grids identified, for example, T3 to T4, and this covers levels 42 to 59. It's just an example. Wings ABC. This was the 1st of May. It's just an example that I'm just putting up, just so you can remember what the document is. Okay. All of them, though, say the same thing in terms of the work. External balustrade cover and sealant. Yep, you got that?
Yeah. Yes.
And let's just look at this doesn't cover level 59, so I'm going to just look at the one that covers level 59. T6, this concerns T6 to T7, 41 to 59, all 3 wings, the apartment and the roof garden, so both sides. And again, balustrade cover and sealant. Yeah.
Yes.
And this is the earliest access date is the 23rd of April 2019. Signed off on the 23rd of April 2019. Correct?
Yes.
Now, obviously, you heard evidence in terms of the sequence of works, and I think you're already familiar with how the sequence of works were being presented.
Yes.
Would you agree that if Reem was in delay, and it was the cause of delays as well from March onwards, then it could have a knock-on effect in terms of when clearance is given or when the handover is given.
So you're asking me if Reem were in delay?
Yeah.
Then they would have a knock-on effect.
A consequential effect. Yeah.
Okay. Logically, that's a sequence to a point. Yes.
Yeah. And we've got the night. I just want to finish off this document. We've got levels 41 to 59, grids T4 to T5, all 3 wings again. Everything's ticked off again. We've got balustrade cover and sealant. And this is dated 9th June.
Just one query. I'm just looking at this log.
Yeah.
It says T4. Sorry. Okay, that was all levels. Okay, I'm just trying to figure out T4 to T5 on level 59.
Yeah.
Cannot be wing A, B, and C.
Right.
So now I've just seen that it's 41 to 59 because the building rotates.
Mm-hmm.
If you look at the side of the building, wing A actually moves around and is not always in front of you. So
Mhm.
that's what just figure. So, but T4, T5 is the same grid line. So, sorry, I understand that now. Yeah.
I'm afraid I didn't understand your answer. Can you say that again?
Okay, what I was looking at, 41 to 59, T4 to T5.
Yeah.
Okay, if this was just a single level, wing A, B, and C cannot be correct for T4 to T5.
Oh, I see what you're saying. But this,
Right.
because it covers multiple levels.
41 to 59, yes, because I
Yeah,
thought
yeah,
I
yeah.
saw 59 before, so that's why I took up to understand the 41 to 59.
Yeah.
Yeah. Right.
Fine. Okay. Now, I want to just make a comparison, please, with the closeout program. And this is page G for golf 2953. It's on screen now. First of all, do you agree with me that when we get to the closeout stage, we're dealing with the very end, the very final works? Because it's closeout, I'm suggesting.
Yes, so this has been said that this is the closeout program and all main works are completed.
Yeah. So
So
now
this
we're
is
in the
purely snagging.
snags. Yes.
So all the work's completed everywhere before
Yes.
the 30th of April.
Correct.
Okay, so we're just in snagging period now.
Yes.
Okay,
Do you agree with that?
I do.
Okay.
If that's what that program is saying, and that is purely, as it's been mentioned in this hearing, that is, the statement was all main works were completed.
And some of the clues are clearly in the wording of the description of the activities. We've got words like snags appearing, touch up, final coat ceiling paint.
Final coat ceiling paint depends on the terminology. That could be actually, there are first coat, second coat, and then a final coat of paint. So that it's an entire another repainting. I mean, touch-up painting, I agree, but final coat ceiling paint is probably the finishing of the painting. Depends what the terminology of the painting contractor is on this job.
Sure, but when we've got ceiling touch-up dated the 1st and 2nd of May, and then we've got the final ceiling paint after the 2nd of May.
And it takes a considerable time to do it. It's not a touch-up.
No, but it could be. But it could be, given that we're dealing with an area. I mean, bond here, because it's bond that's identified, would be dealing with many parts, and one section is the roof garden, which is about 8 meters high.
But you wouldn't start it without scaffolding there. So the scaffolding is decked out, and then you start the paint.
Okay, but it would. But this final. But why? But the final ceiling paint.
I didn't produce it. I can't answer.
I know. I get it. What you're saying is it's subject to interpretation either way, is what I think you're saying.
Yes.
Yeah, but what I'm also trying to elicit from you is that where you've got other contractors doing the snag works, the paint is normally left at the end anyway, in case, for example, there's a scratch caused by another subcontractor. It's just an example, and then you go over it with a paint.
Yes.
And that could be that as well.
Yes.
Okay. Now, looking at the program, we've got it obviously is dated the 30th of April, but you'd agree that the starting date is the 1st of May.
Yes.
Which I think falls in line, sort of, although this is levels 7 to 9. But when we look at levels 56 and 59, this is dated, the first date we've got is 2nd of June, unless I'm mistaken, for level 59. I'm trying to use my cursor to get the right date for you.
I think that was it.
I think it's March.
No, if my lord goes right to the bottom,
Yes,
right at the end.
I've got my
this.
report.
So you're right. Yes, I was wrong.
Yeah. So I think it's 2nd of June, isn't it, Mr. Spall?
Yes.
Perfect. And we had looked earlier at level 59 in terms of the WIRs, and there was a 2nd of March inspection date, 3rd of March. 2nd of March submission date, 3rd of March inspection date, and it got an E. And I
Yes.
appreciate you haven't seen the WIR itself, so we are. You would agree with me that we are hampered slightly with the absence of information. Is that right?
Yes.
Because it could have been an incomplete, for example, waiting on other works to finish, or it could have been an incomplete because of something wrong with the works. We just don't know.
No, sorry. Did you mention the 15th of March in that?
I didn't. I think my lord may mention it, but
No, I didn't.
oh, I certainly didn't. I was saying
Okay,
that the WIR inspection date was the 2nd of March for level 59,
Yes.
and the inspection date was the 3rd of March for level 59.
Okay.
And we had an E rating. Or an
Yes.
E. And I think you agree without looking at the WIR itself, we're hampered slightly.
Yes. Yes.
But if we're trying to fit it in with the chronology of what we've been looking at in terms of our main completion of works and then the closeout, handover and closeout,
Yes.
it appears that at some point after the 3rd of March, maybe in April, trying to take it as best guess as possible, the works were completed to the glass balustrade installation was finally completed. Is that? I think we can agree on that.
It was finished when?
So remember, the 3rd of March was the inspection date for level 59.
Okay. So
We got the E.
there in the 2nd of June, you're saying?
Yeah, and then we've got the handover for level 59 on the 23rd of April. So trying to do our best, the best as possible. It's in between those dates we can deduce that the works were deemed completed.
I've not seen when those works were completed because this is just the planned completion program. It's not actual. It doesn't say it actually happened on these dates.
I know. What I'm saying is it must be between those dates, surely, because the glass balustrade would need to be installed before the handover is done for the cover and sealant works.
I agree with your logic.
Yes. Okay.
But I can't see it here.
Fine.
This was a 1 month period, wasn't it? This completion program.
Yeah, but what I'm taking in stages.
Sorry. Apologies.
That's okay.
Apologies,
Taking in
Councillor.
stages because I appreciate we're looking at many documents. Ideally, I could put them all next to each other and then go like this. But what I'm trying to we've established that level 59, the inspection date was 2nd of March. 3rd of March 2019 was the inspection date. It got an E, yes. The first date of the handover documents is the 23rd of April, which covers level 59.
Okay.
And then we move on into the closeout stage from the 1st of May onwards. So and I'm looking at level 59, obviously. So
Yes.
Trying our best with the information that we've got at some point, we don't know when, do you agree, after the 3rd of March, 2019, and sometime before the 23rd of April, 2019, the glass balustrade installation works would have been completed, or deemed completed, is the better terminology.
Yeah, I mean, I'm just following what you're saying. So between the 29th of April.
No. Okay.
Sorry.
We're trying.
Apologies, Councillor.
That's okay. Don't worry. Don't worry. It's not your fault. It's my fault. Let me try again. Let's go back. Let's go back to the WIRs. I'm not going to show it on the screen because we've looked at it.
My lord,
So,
may I? Sorry. May I just use a pen to write down these dates?
Of course, yes.
Right, it is my report, which is it's not been edited. I'm just
No.
just so I can try and understand council's.
Mr. Spawley, you're an
Right,
expert. You have duties to the court. I'm not suggesting at all that you're doing anything improper.
No, I've just wanted to make
Yeah,
sure
yeah.
my lord was happy with that.
Yeah. WIRs, level 59.
Yep.
Balustrade glass installation.
Yep.
2nd of March is the date of submission.
Yep.
Date of inspection, I said the 3rd of March, that was wrong. 5th of March.
5th of March.
2019. It gets an E.
Yep.
Okay. Then we've got the handover documents. Okay. I'm just going to, because I want to make sure you've got the right information. The next date to give you is the 23rd of April, 2019.
Yep.
And remember, this covered levels 42 to 59.
Yep.
T7 to T8. I don't think that necessarily is relevant. But
just for my benefit, can you just explain what the handover document shows for this purpose?
For this purpose is the handover from 5 to Reem to do the external balustrade cover and sealant works.
Yeah.
All right, Mr. Spawley, you follow with me so far?
Yes.
So, given that the balustrade glass installation was given an E on the 5th of March, 2019,
yep,
which is not an approval for whatever reason. We don't know the reason. As you've said, you haven't looked at the WILs. And the handover, which takes place on the 23rd of April, 2019 for level 59, it's in between these two dates that the balustrade glass installation works would have been completed or approved. Another way.
Yes. Yes.
Great. Now, you recall in terms of the hand, you may want to make just a quick note of the date as well. But the last handover, sorry, I didn't mean that facetiously at all. I just meant because we're dealing with a lot of information. At G2929, we had the handover on the 9th of June, 2019. That included level 59. Again, it's the balustrade cover and sealant works. That's the 9th of June, 2019. That's the last date. In between the 23rd of April, 2019 and the 9th of June, 2019, there were various other handovers. I think we'll agree on that without having.
Yes.
Right. The closeout programs started on the 1st of May, 2019.
Yes.
And went all the way until the 8th of June, 2019.
Yes.
So what we have is that the handover, we can look at the details later, but you'd agree that there is a progressive handover for levels, for level 59 in terms of the work, the balustrade cover and sealant works.
4159 was one on the 9th of June, you said.
Yeah, but if you remember the 23rd of April, we had a handover as well. So yes. Between the 23rd of April and the 9th of June, 2019, we had some handovers in terms of the external balustrade cover and sealant.
Okay.
Okay. Trying to fit that in with the closeout program. Okay. The closeout for level 59, the first date for level 59 was the 2nd of June, 2019.
Yep.
And so what I'm saying it shows is that the handovers are being progressively given as well in conjunction with the snagging works. Would you agree with that?
Yes.
It appears that way. I appreciate we don't have we can't, because of the lack of an as planned as built, we can't, you know.
We would assume those handovers have happened.
Exactly.
All right. Can you just, I once knew this. What does the closeout program show? in terms of what activity is shown in the closeout program?
Can I assist? I made the suggestion that this is the snagging works, and I think Mr. Spawley agreed with that in terms of the closeout program. Is that right, Mr. Spawley?
Yeah, that's what's been said. The program was produced for snagging works.
Right. Okay. Thank you.
Okay. Right. Thank you for bearing with me.
Therefore, sorry, Mr. Spawley. Therefore, if a date is given for closeout of a particular thing, it means the snagging work has been done. Is that right?
No, that was the completion program. Sorry, the work has been done. Yes, from my view,
Yeah.
if I'd been told to go and snag something, I must have completed it.
You mean Reem, I think. If Reem had been told to snag something, they must have completed it.
Must have completed it.
And the closeout program shows when they've completed the snagging?
No, it's the planned program of when we want you to do the snagging.
I see. So it comes at the stage of completion of the actual job, but before snagging.
The completion program is the snagging program in essence. They're
So
using completion, but it is snagging.
Thank you. Yeah.
In fact, my lord has anticipated the next questions I was going to ask, which
Sorry.
is no. But we're all going the same direction, which is this is just the program. This doesn't actually reflect what really happened. That's right, isn't it, Mr. Spall?
The planned program.
The planned program.
Yes, doesn't represent what actually happened.
Correct. And in fact, you may remember yesterday. I can't remember if I've got it. I can't find the page reference, but you may remember Mr. Nair looked at some emails which made a reference to a delay in the snagging works and the de-snagging works. And I'll need to find the page reference. But you recall that, don't you?
I do recall.
And that showed, again, we can clarify this because I will get a page reference, but unless I'm mistaken, the snagging works were slightly delayed, and then the de-snagging works were consequentially delayed as well. And we went into June and July. Do you recall that?
I do recall. Yes.
Okay. And in reality, that's good evidence to use to show when the snagging works, not on a level by level basis, but as best as possible, how the snagging works were progressing. Agreed?
I'm not sure how I can deduce that.
Okay, let me try another way, and I've got the page reference, so it might be better if we look at it, because I appreciate we're dealing with complicated-ish areas, but F1395. I will get the page up for you, Mr. Spall. Just again, just bear with me slightly. Yeah. So just to familiarize you again with this is, sorry, F1394. This is an email on the 11th of July 2019 from Rajaz Bashir. And it makes a reference to a project progress meeting on the 10th of July 2019, saying, please find attached JVD closeout snag summary dated 10th of July 2019.
Yes.
And the closeout snag summary, I know we don't have it, but generally, what does it show? Do you know? Or is it a case by case basis? We just need to see. Okay, fair enough.
Because it was called a completion program, now it's called a closeout snag summary. So they're using different terminologies.
Fair enough. The main point here is this. Oh, that's the wrong contractor. Yeah. So this is page F for Foxtrot 1397. Reem to complete closeout, including master bathroom flashing until level 34, 15th of June. And then an increase in manpower. Reem confirmed to recover delays by 15th of June, and if failed, etc., etc. Now this is a comment in red, and here we know where it comes from because it says here on the 13th of June, with reference to discussions on site progress today, please find the update for the below mentioned points in red. So this is where it comes from in terms of the red commentary.
Who put the red commentary, sorry? 5 or Reem?
Yeah, 5.
Right.
And then we've got, there was a reference to snag and desnag. Yeah, we can see somewhere, you know, like complete desnag or full desnag. For Reem, it said something like, yeah, Reem has completed desnag until level 34 and to complete full desnag by 20th of July.
Yeah.
You see that? So
Yes.
I appreciate it's just an email, and as I say, the limitations are that, my lord, you're on mute.
Just want to know what page it is for just for trying to make sense in the transcript. 1394, thank you.
1394 and going through until 1397.
Yeah.
So what this show, doing the best we can again, as I say, because we are limited in the information we have. And when I say we, I mean everyone. It appears as though the snagging and the desnagging has progressed throughout until some point in July.
For the project, yes.
For the project, yeah, for the project. And for Reem, in terms of the desnagging, again, this is just a scheduled or a planned completion date to be accurate.
Yes.
It is suggested to be by the 20th of July 2019 for the desnag. Correct?
Yes, that's what it says.
Yep. And I think yesterday we, or maybe the day before, we confirmed that the process is main works, snagging, desnagging.
Yep, there was 2 months originally allowed for snagging and handover by Reem.
Right. Great. Now, I believe you did have this information with you, didn't you, when you did your report? Because this is an exhibit attached to Mr. Al-Mahdi's witness statement.
Yes.
But you didn't use this email, did you, when you gave your opinion, correct?
No.
When I'm moving topics, that's why I've taken off screen. But you would have recalled that we've seen a variation order in this case, dated at some point in the end of June. I think it was 27th of June, unless I'm mistaken. But it's the glass variation.
Yes.
Engineer's instruction. Sorry, excuse me. Engineer's instruction. And in fact, I might be able to help you with this. The engineer's instruction 0098. That's the number for the EI. Is at page Echo 1722. Unless you need me to take you to it, Mr. Sporty, I wasn't proposing to, but if you want to.
No, I'm fine.
You're familiar enough with it, I think. And the evidence yesterday was that from Mr. Al-Mahdi, and I appreciate this is not for you to give an opinion on, but I'm just reminding you, he said that the engineer's instruction was clear. He at least in his opinion, didn't think it was ambiguous, etc. But but in terms of the effect of an engineer's instruction, this is what I want to ask you about. When an engineer gives an instruction, do you agree it needs to be complied with? Well, the effect, yes. Yeah. And if there are commercial issues, and when I say commercial issues, I mean like variation orders or back charging or anything like that, would you agree should be dealt with later?
Yes.
Or best practice.
Well, depends what the instruction is as well. For you, if you get an instruction, you can't just follow it. If there's a problem with that, you should go back and query the engineer on that instruction.
But where you think there's a problem, or where it's unclear, or where it's ambiguous, as examples, yes?
Yes.
But if it's saying replace all the glass, and that's part of Reem's work order or responsibility, etc., Reem should be. Well, let me be careful, because I appreciate you're an expert witness. When the instruction is to replace all the glass and it's within the scope of works, normal practice is the instruction is carried out and any financials are dealt with afterwards, as the engineer said at the bottom of his instruction.
Under the terms of the contract and FIDIC,
Yeah.
I would agree with your logic, but on this specific at that time, I can't comment.
Okay, fair enough. I think that's probably as close of an agreement we'll get. Fair enough. The WhatsApp messages. You agree that I think maybe the evidence was that they deal with levels 39 and 40, which are the mechanical floors.
But the last ones, yes.
Yeah. Now, the cradles were, I don't know if you know this as a fact or not. Tell me if you don't. The cradles were attached to 39 and 40. Do you know that it's a fact?
I understand that they were attached to 39 from the evidence we've heard.
Oh, fair enough. Okay.
Yeah.
But in terms of the way the cradles work, they're used by contractors for other floors. They're attached to 39 and 40, but they use them to do works to other floors.
Yes.
And we've had the evidence that works to 39 and 40 couldn't be carried out unless the cradles are removed.
Yes.
Yeah. So logically, again, it follows that the works need to be concluded to the other floors before the cradles are removed on 39 and 40.
Yep, it's the same principle as the tower crane.
Thank you very much. Thank you, Mr. Spawley. No further questions.
Thank you. My Lord, you're on mute.
Mr. Carbenis.
Thank you, Your Honor. I will be very brief. Mr. Spaulding.
Yes.
Let's talk quickly about the working space handovers. I wonder if we could bring one screen for anyone. Doesn't really matter. I don't want to look at any particular one. Anyone will do. If you can remember the contents, we don't need it, but okay, we got it. I assume. Yes, we have it. It doesn't really matter. Now, you said that it shows the grid,
Yes.
the wings,
Yes.
the floors, obviously, the wings. And this is for this particular grid. There are plenty of grids, and this is for this particular grid. Right?
Yeah, on each of those floors, there would be various grids.
Okay. Now, and it describes the work that this working space handover is about. Right? Here I see external balustrade cover and sealant.
Yes.
Right?
Yes.
Am I right to understand that this is the last piece of work to be done by Reem before snagging or replacing broken glasses, etc.?
Yes.
This is the activity that finishes their scope, right?
Yes, from what I understand, yes.
Now, what is the predecessor activity? What activity needs to be completed for this site handover? For this handover?
The EIFS.
The EIFS. So, and we have this particular one is dated, let's see the date.
9th of June.
5 of June. So, 9th of June. So, what we can tell from this handover is that on 9th of June, EIFS works were completed, correct?
Yes. Or before.
And
Yep.
on or before 9th of June were completed, so that Reem could continue with the final piece of work, right?
Yes. Yes.
And what we have is the 5 arguing that all EIFS works were completed on 3rd of March, This is what 5 is telling us. All EIFS works were completed 3rd of March, and 5 waited 3 months to give. So they were finished, and they waited 3 months before they handed over this workspace to Reem. Do I get it right? Is my logic right?
Yes, the date issued under the Akiki report doesn't reflect this.
Right. Let's move to the closeout program. Again, we don't need to see. Is this an as planned or an as built program?
Sorry, apologies for one. I've just had a technical problem.
So I didn't hear that either. So can you, in a moment when Mr. Spall has solved his problem, can you repeat it, please?
Sorry, I just had a technical problem. My screen just turned itself off. Apologies, I'm back on my laptop.
You're back on. Mr. Carvelis, you'd like to repeat it?
Sorry, Mr. Carvelis.
No worries. We all had our fair share these days. I was saying the closeout program. I was talking about the closeout program.
Sure.
Now, is it an as planned or an as built program?
As planned.
So we don't really know what happened on the basis of this program.
No.
How, if it did progress the way it was supposed to progress, correct?
Yes.
Now, I see in this closeout program a very long line for AIVs and a very short line for IN.
Yes.
And the last 2 days seem to overlap. The last 2 tables seem to overlap. So I assume that AIV's works were required for whatever the purpose of the closeout program was. Am I right?
Yes.
And even at that time, at the closeout program, still it was AIV's EIFS first, Reem after.
Yes.
Am I correct?
That's what was planned.
All right. Next question about, and I will ask you with your capacity of delay expert and not lawyer to be as my friend. The broken glass replacement instruction, let's call it broken glass replacement instruction, which was issued in July, August, I can't remember. From a delay analysis point of view, is it on the critical path?
I would say no.
Did it delay completion of, I should add perhaps that the glasses, the broken glasses were in place 15th September, 30th of September, we know that took time, went all the way into October. So is it on the critical path from a delay analysis point of view?
No, purely based on that, the fact that the variation came, replacement glass was ordered, the hotel opened before the replacement glass was finished.
So, so from a delay analysis point of view, the issuance of the variation order is on the critical path. Correct?
The variation
Yes.
order of the
issuance of yes. The issuance of the order is critical because it shows an instruction to work.
Okay.
I think, sorry, my lord, I think my learned friend needs to be careful because he's cross-examining, and I think he needs to ask open questions. This arises from cross-examination, no issues, but I think he needs to ask open questions, not leading questions.
Well, there's always been a bit of controversy about whether that's in re-examination, but I'm sure Mr. Carvelis will maybe make it more open than it presently is.
I will move on. There's no point. I think the expert answered already. And two more questions. One in relation to inspection requests, and the last one will be about the credits. inspection requests. I saw this number there, and we said that it is incomplete. Do you want to put it on screen? Do you need to put it on screen again? Perhaps we could. My question is, I see there is also in the ledger another box which is red, C, rejected.
Yes.
Presumably there's a difference between resubmit and reject. Am I right?
Yes, there is a difference.
And if it was on the information that we can get from this table is that we cannot say, we can tell when the latest day on which works were completed, which is the date of inspection, right?
Yeah.
Conceivably, the contractor, if it submitted a request to inspect on 4th of October, maybe he did not finish. He finished at the end of the 4th of that day, and it was inspected on the next day. So we know the latest date on which works were carried out.
Yes.
Which were inspected. Can we tell if these works were late or not on the basis of that information in the inspection request?
No.
No. And we know that some were rejected, but some were, the code was resubmit. And there's a difference between them, right?
Between rejected and resubmit, I would say yes.
What is the difference? What?
I mean, I haven't seen what the coding says from the engineer, but in my experience, a rejection means do not proceed, replace, change it, it's wrong. And a resubmit is maybe you've got the documentation wrong. But I'm not party to what this contract said from the engineer's approval status.
Okay, thank you. And the last question about the cradles. If you happen to know which contractor, or to be precise, because of this dispute, which of, if 100 units of time are allocated, how many are used by the EIFS contractor and how much by Reem for cradles?
I haven't seen that information to say what the split at the time. I know what Mr. Amadi said, but I haven't seen that just from the completion program, but that's the snagging. The period was far greater than what Reem's period was. So if that's the same principle applied to the installation of the works, then the EIFS would require the cradles a lot more than Reem.
Okay, I was asking from your general experience, but I think this will do. I don't have any other questions, Your Honor, for Mr. Spore.
Well, thank you, Mr. Spore. That's your evidence finished, and you're free to go now. Thank you for your help.
Thank you very much. Thank you. Thank you, everyone.
Thank you.
Right. You're making remarkably good progress.
You need to give us credit, Your Honor. Both my colleague and me, we have been really, really fast to the point and focused today.
It's about time, though, isn't it, for us?
We're tired. We're tired. That's why.
Right. The next witness, the last witness today, is Mr. Craig.
Yes.
We had planned to have him at about 10 past 1, 10 past 4 your time. It's now rather earlier than that. What do you want to do? Do you want to stop for lunch at this stage and then have Mr. Craig resuming in an hour's time? We need to discuss the Mr. Carvelis application at some stage. What we could do is have 3/4 of an hour for lunch and then come back and discuss the application and then deal with Mr. Craig after that. Would that be sensible?
If it's not too early for lunch for you, Your Honour, it's still quite early in Scotland. That's why.
It's still early in Scotland for lunch, but all this week I've been having a sort of brunch.
Okay.
But what is it sensible to? I mean, you presumably still want time to consider the application, or are you ready to discuss it now?
I can discuss it now. I've taken instructions.
Well, let's discuss it now and then break for lunch.
Yes, certainly.
What I'd like to know, Mr. Carvelis, and perhaps we can I just want to firm up on this. The point you're making, hang on, is in relation to the re-examination about the drawings, which
Yes.
I can't now remember the reference to the drawings, but does anyone know the reference to those drawings?
Yeah,
F1214
F
to 1216.
F1214 to 1216. I think, are they not, Mr. Costello, those that were on Mr. Sporl's expert report also?
I can't. I'll be honest. I can't recall, but I'll see if I can just quickly get it up and confirm the pages. I made a note. I'm just getting my notes up, and I'll
No. Yeah, what's the number again?
I can display.
Yes, we can display it. Yes.
Submitted to this level.
Yeah, that's one of them.
That was one.
That's 1216, I think. Is that right? And the other one is.
Yeah, 1216 and F444.
F444.
F444 was one of them. Yeah, F444 was the first one I looked at, and F1216 was the second one. So in terms of the PDF, if it helps my learned friend, it's page 426 of the PDF and 1198 of SA1.
426 and 1.
426 of SA1 in terms of the PDF.
Yeah.
And 1198. 1198.
Okay. Yeah, it's a bit. Okay.
But you need to look at it in terms of the actual exhibit to SA1 that was originally submitted.
Yeah. Thanks.
So give me those numbers. Give me those numbers again to the exhibit.
426.
Yeah.
1198.
Yeah. Thank you.
You're welcome.
Carvelis, you're saying that the questioning about that went beyond the legitimate scope of re-examination. Is that right?
Yes, yes. In a nutshell, yes. And plus, there were allegations there that my client is adamant that they were entirely false and they have no other way of addressing them, but they are technical issues. They cannot be addressed, for example, because I thought of that. I asked this, if it could be addressed with the closing submissions, in the closing submissions, but it has been, they insisted that it is very technical and it cannot.
And this is to do with sequence, is that right?
Yes, the sequence of work. What is predecessor, what follows, which explains what really happened and the causes of delay.
And is this not an area covered already by Mr. Al-Mahdi in his witness statement?
Yes, it is in relation to the, you may recall, Your Honor, Mr. Al-Mahdi in his witness statement described a sequence of works.
Yes.
I asked specifically Mr. Akiki. Mr. Akiki in his own witness statement confirmed that he agreed with the sequencing. I asked Mr. Akiki specifically, because it was important to establish a basis to discuss. And then during the re-examination, it appears that we looked at it a little bit in a different light.
I see. Right. Then we have.
I could be more, excuse me, apologies for the interruption, Your Honor. I could be more specific, but if I do, I will preempt the examination, which I don't think it will be, it's the proper thing to do, to testify on behalf of Mr. Al-Mahdi what he wants to testify. I can give you the idea.
I've got the idea, I think. Mr. Costello.
Yes, my lord. This this re-examination arose specifically from my learned friend's questions in relation to the photograph that was shown to him, and it was being explored with Mr. Akiki when the eaves would be installed. And Mr. Akiki was making the point that the photographs that were being shown to him dealt with the fascia, the outside, putting it quite simply. The facade works, I should say. And when he was being, he said that it was standard, Mr. Al-Mahdi said that it was standard, sorry, excuse me, Mr. Akiki said, in answer to a question, that Mr. Al-Mahdi had said that the standard industry practice is deal with eaves first and then glass to avoid glass being broken. Mr. Al-Mahdi says that Nabil Akiki had changed the sequence to glass first and eaves, and that eaves had broken 150 panels.
Yes.
And so that was one of the answers given. And Mr. Akiki was again disagreed with my learned friend's suggestion that eaves did the works first and then the glass and then the cover. That was one of the final questions that Mr. Carvelis had asked. So in order to get a clearer picture of what was being asked of Mr. Akiki, because Mr. Akiki was just looking at a photograph from the outside in terms of the glass.
But is that the dark photograph?
Sorry?
Is that the dark photograph?
That was the dark photograph, which I think there may be a better version lurking around in the bundle somewhere. Yeah. That was, but my lord is right. My lord's memory serves him, it is correct. But that's why this had to be explained with these drawings to try and understand what Mr. Akiki was answering in relation to my learned friend's questions about when the facade how the facade works were done, but specifically in relation to eaves, because that was the whole cross-examination in this section was to do with when eaves did their works, who was responsible for the breaking of the panels, why eaves had to come after the glass and the cover and the sealant. And this was so it specifically arose from my learned friend's questioning. Now, what's happened is my learned friend's witness, Mr. Al-Mahdi, just doesn't like the answers. He's not satisfied. But I'm afraid that's just not, it is what it is. The evidence has been given by Mr. Akiki in re-examination, which properly arose from being cross-examined. My learned friend suggests that Mr. Akiki was briefed or was aware of the answers, but he wasn't. He wasn't on the call on Tuesday. He was traveling. Certainly none of us have spoken to him about the evidence of the case. No one has discussed the case with him. So he's not aware of what Mr. Al-Mahdi said or didn't say in cross-examination. This was a very nuanced point, and it arose specifically because my learned friend decided to ask Mr. Akiki questions on the glass and eaves. And that's why when he was re-examined, it was taken upon me to just have a look, to explain exactly how the process works, to explain why the eaves comes afterwards. And in fact, Mr. Akiki also, unless my memory is wrong, had said that eaves came after the glass balustrade, but in respect of one of the two, and I think it was the latter, unless I'm mistaken, the one on page, the latter, the one on page 1198, but F1216. Yeah. He said eaves had to be installed, or it could go the other way. I think he was a bit more open about which way around it could happen in terms of the eaves and the glass.
My recollection on that is that he said this is where there was the sort of U-shaped thing for the glass to go into. And he said that you could, in fact, do that when the concrete was in place, do the eaves when the concrete was in place, and before the glass went in, if I remember correctly.
If Manol just bears with me 1 moment, sorry. I'm just getting the picture up myself. This was the U channel he was describing, yes.
U channel, yeah. I think accepted that you could do the eaves before the glass went in, I think.
Yeah, and I don't know why my learned friend is taking issue, because I think that Mr. Akiki fairly was accepting it could be one or the other, and that's why I say it goes either way.
Well, anything else you want to say about this application? You oppose it. You oppose the application.
I oppose it. Sorry, I should say I oppose it on the basis that it directly arose out of my learned friend's questions to Mr. Akiki on the eaves and specifically on the external facades, and that's why Mr. Akiki was shown this in particular, this diagram.
Is there anything else you want to say, Mr. Carvelis, about your application?
Yes, very few things, Your Honor. First of all, I don't want to any misunderstanding. I don't suggest that my colleague, my learned friend, tried to talk to Mr. Akiki or had an interaction with him between the 2 days. I have no reason to believe that. I have no evidence, and I have no reason to believe, based on our cooperation, I would say, on this trial. This applies, though, to my learned friend and my learned friend only. I can't tell about anyone else. The cross-examination to Mr. Akiki was in relation to the external eaves, and that's what I showed him on the picture. I tried to show him on this, as you said very well, not very clear picture.
On the dark photo.
Yes, the dark photograph, yes. And we do have a clearer version somewhere in the bundle. Your Honor. But yes, and these were my questions. Actually, we were pointing with, you may recall, we were pointing with a mouse. This photograph is of an external photograph of the building, and we were pointing with the mouse on particular parts of the building. And this was following up the questions of what the discussion we had, the debate we had with Mr. Akiki on what age, balcony's completion, factual date mean, if it means including or excluding, if you recall.
Yeah.
And these were the questions. Mr. Akiki, I do agree. My colleague just asked one question and then sat back. And then Mr. Akiki gave a speech of half hour, which ventured to practically everything, including a very detailed analysis of how works were completed within the building. Not on the balconies anymore, but within the building. And he made a description of the works that my client, the defendant, insists that it is entirely inaccurate, and they have no other opportunity, realistic opportunity, to defend against these allegations, but for a very short 15-20 minutes opportunity of Mr. Al-Mahdi to respond to these particular allegations by Mr. Akiki. It goes without saying, obviously, that if you allow it, and it turns out that Mr. Al-Mahdi his testimony will not be in direct response to Mr. Akiki's testimony in the re-examination. I have no doubt that my learned friend will note this, object, and perhaps even request that this additional part of Mr. Ahmadi's testimony will be stricken out. So I honestly, I heard my friend, but I don't see the harm. It's not whether Mr. Al-Mahdi is satisfied or not with the testimony of Mr. Akiki, it is whether Mr. Akiki's testimony is accurate or not. That's all, Your Honor.
I just want to be clear. When you started off, I thought you were applying to cross-examine Mr. Akiki. Now you seem to be asking to recall Mr. Al-Mahdi.
No, yes, apologies, Your Honor. I thought it was clear. No, we do not ask that we cross-examine Mr. Akiki. We are asking to permit Mr. Al-Mahdi to...
Okay. It's my fault. I misunderstood at the beginning. I'm sure I don't suppose Mr. Costello had the same misunderstanding, but what I will I think it's important in this case that the evidence come out as fully as possible on the critical issues. And it seems to me that although I think it is probably the case that Mr. Akiki's answers were within the proper scope of re-examination, and a witness always goes beyond the question, inevitably in my experience. Nonetheless, I think in the interests of getting out matters fully, I will allow Mr. Al-Mahdi to be recalled to give evidence about these two documents, these two documents and their effect in understanding the sequence of works on these areas covered by these documents. But I'll limit it to that. and I'll allow examination in chief, cross-examination, and re-examination briefly on these matters. Now, in terms of timing, I emphasize the limits of what I'm allowing. In terms of timing, is it best to do it after the last expert witness?
I would suggest so, from my perspective.
Yes. What we'll do, we'll adjourn now it's now 11:42. Say 11:45, 12:45, which is 15:45 your time. Should we call Mr. Craig at 15:45?
Yes.
Will he be? We have allowed 2 hours for him, but by the standard of the previous witnesses, it probably won't take that long. And after that, we will allow Mr. Al-Mahdi to deal with these points. But please, Mr. Carvelis, emphasize the limited nature of the questioning.
Sorry, my lord. Maybe I didn't make myself clear. Sorry, that was my fault. I was suggesting that maybe that we can deal with this tomorrow after Middleton and Levine, because I want to take not just instruction. I've taken instructions on obviously the application, but I would like to discuss with Mr. Kiki, who's in Switzerland, and I haven't been able to speak to him for those reasons. Yeah.
I see. Very well. It doesn't matter to me, so I think we can do it tomorrow after the witnesses. Is that right, Mr. Carvelis?
Likewise, Your Honor, I would like some time also to answer the previous question. I don't intend to do any long examination in chief. It will be very short, the examination in chief. Then I intend to let Mr. Al-Mahdi explain what he finds so wrong. And then I'm sure Mr. Costel will do his own cross-examination. I will be very short. I would suggest, though, I don't know if you, of course, you're agreeable and my learned friend is agreeable, if we can do Mr. Al-Mahdi in the morning. If we start with him, I assume you want to limit the time available for this further examination of Mr. Al-Mahdi. I will have no objection whatsoever, obviously. So we deal with him in the morning, we finish, because at the end of the day, the issues for Mr. Millington and Ms. Levine are not relevant to this discussion. They deal with the quantum of a different part of the dispute. So perhaps it would make more sense to finish the first part and then go to the quantum of the other part.
Mr. Costel, do you have any difficulty with that?
Not at this stage. The only reservation I put is just depends on when I can speak to Mr. Akiki, which I hope will be today. But again, I don't know his plans. Okay,
we'll say this, Mr. Carvelis. We'll aim to start off tomorrow morning at 8 o'clock or 11 o'clock your time with Mr. Akiki. But if Mr. Costel has not had the opportunity of talking to with Mr. Al-Mahdi, but if Mr. Costel has not had the opportunity by then of speaking to Mr. Akiki, we'll have to deal with him later. Okay?
No objection, Your Honor. Thank you very much.
Let's resume at 12:45. That's 15:45 your time with Mr. Craig. Thank you very much.
Thank you. Good morning. Good afternoon again, Your Honor.
Good afternoon. Give me 1 second. Right, are we all ready to begin?
Yeah, I believe we are.
Yes.
Good. Mr. Craig, is it? Are you?
Yes,
good afternoon.
Good afternoon.
We've got the feedback on someone's phone, or has everyone got their phone on?
Yeah. Still feedback?
Can you speak for a second, Mr.
Hello, can you hear me?
Yeah, I can hear you. Can everyone else hear?
Yes.
Yes.
Very well. I'll ask the court administration to administer the oath before you give your evidence.
Okay,
Thank you.
Thank you, my lord. Good afternoon, Mr. Craig. Could you please state your full name and occupation for the record, please?
Full name is Paul Stephen Craig. I'm a senior director at GMCS.
Thank you. Could you please confirm if you're taking an oath or an affirmation today?
Affirmation, please.
Thank you. Please repeat the following statement after me. I solemnly declare and affirm
I solemnly declare and affirm
that the evidence I shall give
that the evidence I shall give
will be the truth, the whole truth, and nothing but the truth.
will be the truth, the whole truth, and nothing but the truth.
Thank you very much.
Thank you.
Thank you. Mr. Calveris.
Thank you. Good afternoon, Mr. Craig. Nice to have you here. For the record, you have issued one expert report dated 19th April 2022. Am I correct?
Correct. I have them here.
And for the record, Your Honor, this can be found at G for Golf 1505.
Yes, I have it. Thank you.
Thank you. And which goes all the way to G1562. Yeah, do you have it with? Do you have a hard copy with you, Mr. Craig?
Yes, unannotated. Yes.
Right, so that I don't have to show it on screen. Can you confirm that this is your report?
This is my report.
You're the author of the report. Thank you. Excuse me.
Sorry.
Give me a second. And yeah, I was reminded to make sure that I asked you that you confirm that the report was amended by an addendum, which you, yes. Which,
I have the amended report here.
and I understand this addendum reduces what you have assessed as Reem's entitlement.
Correct. There's amendments to the assessment for the prolongation cost, the interest on delayed payment, and the bonds.
Yes. Thank you for this, but not the amendments.
Mr. Calveris, can I just clarify, are the amendments, are the amendments now in the report, or is there a separate document?
I think it's in a separate document, and it must be in the bundle. Let me give you the reference, the bundle reference. Amended. This is this one. So yes, I am told, and I will check in a moment to confirm. Yes, it is at G for Golf 2967 to 2979.
Thank you.
And it is dated 24th June 2022. Do you confirm, Mr. Craig?
Yes, I confirm.
Thank you. Now, very few introductory questions. You are a quantum expert that's what you do for a living. Your profession, that's your profession. That's what you do. Correct?
I'm a senior director. I carry out quantum expert roles as well as overseeing commissions for the company relating to claims.
I will leave it to my learned friend to examine if he wants to know anything about your past experience. Just one quick question. Do you have any previous interaction? Have you worked for Reem Emirates Aluminum before?
No, I haven't.
Have you done? This is the first case, right?
Yes, it is.
Okay. Your witness, Mr. Costa.
Thank you. Yeah, if my lord is content, I'll proceed.
Yes, of course.
Thank you. Mr. Craig,
Good afternoon. I know you've been waiting patiently for your turn, but you'll be happy to know it won't take too long. Can I just the one point of clarification? I'm not taking an issue, but I just want to make sure the formalities are done right. I think strictly speaking, your addendum is not signed, not the one I've seen, and it's not signed on the one that's uploaded. But
No, I apologise for that. On Friday, I issued an email explaining I was out of the office.
I'm not criticising you.
No, sorry, that's correct. I put on the email to legal that I was unable to sign, but I could sign if required.
Yeah,
and happy to do that.
So I was just going to say, unless my lord, you take a different view, for good order, we can get one signed. I'm sure my learned friend can get a signed version uploaded just for good order. But for now, you'll confirm that the contents are. This is your report, and you stand by the comments within the addendum.
This is my report as issued on Friday. Yes.
Okay, so we can take it as though it's signed on Friday.
Yes.
And yes, Mr. Costello, I confirm what Mr. Craig said. He did say to us, he did notify us that he was available to sign from Monday onwards, and I totally forgot.
Well, as I say, I'm not taking an issue, but I thought it's only right to raise as a formality. But if my learned friend would indulge us to just get a signed copy at some point.
We will arrange it quickly.
I'm grateful. Now, Mr. Craig, just a bit about your experience. I'm afraid I didn't catch all your answer. What I caught was that you're a senior director carrying out quantum expert reports, and it's the rest of it I didn't catch.
Sorry, I work also not just as a quantum expert, but also within the company disputes. So the preparation, defence of claims, extension of time claims, cost claims, etc. So it's the construction dispute industry.
Yeah, not as counsel in arbitrations, or you mean as an expert?
No, this is generally, it varies. Assisting counsel, it's producing the claims for the contractors, defending the claims for the employers, the various roles that you'd expect as a claims consultant to carry out. Okay,
fine, fair enough. Now, in terms of your experience, I wanted to ask some questions. In terms of your background, how long have you been a quantum expert for?
It was just before 4 years was the first time I gave evidence, oral testimony. So for the last 4 years, this is my 6th time appearing.
Oh, fair enough. Well, let's hope you have many more appearances in the future. But in terms of your background, what qualifications do you possess?
I hold a degree in quantity surveying, a MSc in construction law, a law degree, and a master's in law. I'm also a chartered quantity surveyor and a member of the CIRB.
And in terms of your employment history, what roles have you undertaken?
How far would you like me to go back?
Just give me a flavour. Let me ask another way. I want you to answer, but I want to help you. Were the roles that you undertook engineering roles or QS? QS type roles?
Just quantity surveying on site. So from a junior quantity surveyor, assistant quantity surveyor, a lead quantity surveyor, and then for probably the last 15, 16 years in the disputes field.
Right. So just to make sure I've understood, you haven't worked as a project manager?
No.
You haven't got architectural experience?
No.
And I understand when you gave your you've obviously heard the evidence given today, but in terms of one part of the quantum that you've dealt with are the design drawings, and I'm looking at paragraphs. For my purposes, paragraphs 52 onwards of your report. So in terms of the page number. I've got the wrong report open. Bear with me.
1531 onwards.
Yes,
Golf
thank you.
1531. Thank you. And you looked at some additional documents provided to you by Reem. Yes.
The drawings were not provided. While I attended site, I asked to see the drawings produced.
When you attended site?
Attended the client's head office.
No, I understand. I just wanted to clarify that that's when it happened. In fact, before I carry on any further, let's just clarify what you did review. You were in possession of, I think we can generally call it the pleadings. Is that right?
Correct, yes.
You referred to paragraph 5 of Reem's particulars of counterclaim and 5's defence to counterclaim.
Yes.
And Reem's reply to defence to counterclaim. I don't think you looked at the amended particulars of counterclaim, did you?
I don't believe so. I would have noted those.
Fair enough. You looked at the witness statements of the respective witnesses, including their reply witness statements.
Correct.
And when you said all exhibits which accompany the above, which you've termed the documents, that's only the exhibits, other than where you say otherwise, but in the reference in paragraph 5, that's only the exhibits that came with the witness statements.
With the documents and the particulars, yes.
Yeah.
With the above, yes.
Yeah, but including the witness statements, not just limited to the pleadings.
Correct. Witness statements, yes.
Yeah. And there were instances where you did review further documents, didn't you?
Yes.
So one of those is that which has been exhibited to your first report, your main report, let's call it that, which is Exhibit 1, correct?
Sorry, I just...
Paragraph 52.
Yes, the variations.
Yeah, where you asked for additional documents when you were at Reem's head office.
Yes.
Who was the individual who was providing you these documents?
Mr. Saravana.
Mr. Saravan, we've seen his name before in relation to disclosure. So I think his name is Saravan Subia, unless I'm mistaken.
Yes, correct. Sorry,
No, I'm just clarifying so we all know who's who.
Yes.
Now, you asked him for more information. We'll deal with the details in a minute, but just to clarify paragraphs 55 and 56, just so we make sure the scope of what you have quantified is clear, you have not included in your assessment the material costs, so the materials ordered and the use of storage, etc., that sort of thing.
That's correct.
And that's because when you looked at the documentation, you didn't see any evidence of it.
Correct. From the schedule provided, which set out, this relates to the negative variations, my lord. There's a calculation and an assessment of the works that Reem say were carried out, and there was a claim for materials, storage. When I saw the evidence of that material and the storage, there was none available. That's why I've removed it from my assessment.
And I appreciate you've not included it, but I just want to get an idea of what you mean by the materials the evidence that you saw. So just help us, what sort of evidence you reviewed?
Based on the schedule provided and the assessment of the claim, there's a claim for the 5% for the drawings produced, and there was a claim for the materials and for storage, as well as the loss of profit on the actual bill of quantity rate. So in order to carry out that assessment and validate the material costs or the storage costs, I asked for evidence of the material ordered against those items. So the
Give me an example. Give me an example of what you were looking for, just so we understand.
Material delivery notes, payments, invoices.
That sort of thing. Yeah.
Yes.
Okay. And you didn't see any, and that's why you assessed it at nil. Fair enough. And I think you mentioned invoices in paragraph 56, but I just wondered if there was anything else in particular you were looking for.
But no, it's just that anything that would demonstrate that the materials had been ordered, paid for, and were in the possession of Reem.
Yeah. Okay. And so therefore, that's why you've limited your assessment to just the drawings.
Correct. There is no material to be seen, none in the warehouse, so it's just on the drawings produced.
Now, I appreciate your candid answer before you don't have architectural experience, but you've heard Mr. Lowe's evidence and you know his expertise, where he suggests that 5% is too high because when it comes to design works, the architect will do design drawings as well, wouldn't they?
I believe so, yes.
And sometimes, more often than not, maybe because we can't say always, but more often than not, subcontractors would use architects' design drawings primarily in order to do their own drawings and designs.
Correct.
Now, in this particular case, these drawings related to the mechanical floors, correct?
I'm not sure of the level of detail of those. I've just seen the volume of drawings, and
fair enough.
I'm not experienced in architecture.
Fair enough. Anyway, look, I don't think there's any dispute that it does relate to the technical floors. And I appreciate you're just dealing with the quantum. But we're dealing with 4 floors out of, I think it's 59, unless I'm mistaken. So it's quite a small amount. Agreed? Agreed with me?
In relation to the drawings, sorry, I'm not sure I followed it. Yes, it's the drawings for those floors, but this is the specific items, I believe, the bill of quants.
Yeah.
I wasn't aware of the floors.
Okay, fine. But given your concession about architecture and, you know, how drawings are based on some architectural designs, would you actually agree that 5% is on the higher side and it should be 1.75%?
As I say, this is just based on my experience in the region, and my lord, I'm not an architect, and Mr. Lowe made some good points, but 5% for the drawings within the region, there is usually an issue of having to produce significant amount of drawings. So in my opinion, that 5% was reasonable against the bill rate. But as I say, I have made that clear in my report that in my opinion, it's reasonable. But I was unable to check with the timesheets and cross-reference the amount of hours because the timesheets don't have that detail.
Okay. So you haven't been able to look at you looked at timesheets, but the timesheets don't have the detail to show.
Not for those specific drawings, so I can't just set time against those drawings. The architects, the technical details are produced in one batch, and it's not separated out per floor, per area, per item.
Yeah. So does it come to this? And I don't want to be unfair to you. That's why I want to give you the opportunity to answer. Mr. Lowe is perhaps a bit more experienced than you in this area. Agreed?
Agreed.
And he has certain knowledge of architecture which you don't have, and therefore would you accept that it might be that something less than 5% may be more appropriate?
Yes, that's fine. It would just alter the calculation for the loss of profits at the end as well.
Of course.
It would change the sheets.
Yeah.
Not just that one item. It has a knock-on effect. So it's a calculation that can be carried out.
It may be that, and I don't think this is just limited to you, actually. I think it may be to other experts as well. It may be that depending on the findings, we may need some more assistance in
Yes.
future. But anyway, your answers are helpful nonetheless. Thank you very much for that. In relation to the, I'm going to ask you about the, let me just bear with me because I've got a tick list that I need to deal with. Yeah. So I want to just quickly deal with the interest charges, which, unless I'm mistaken, I think this is in your addendum.
It's been revised just to consider compound interest, my lord. That's so rather than an alternative, it is purely the compound interest.
All right. In terms of the, did you review the contract itself, the subcontract agreement, when you?
I reviewed briefly just to check the payment dates. My instructions were to calculate the interest from the date that the payment should have been made.
Right. Only because I wondered, because when it comes to, for example, the advance payment guarantee, I don't know if you agree with me, but there are certain conditions that need to be fulfilled before that's payable.
Yes, I understand.
You agree with that?
Yes.
And one of them was that the guarantees should have been issued.
Yes, I'd make a note of that. That's the clause.
And were you aware that the performance guarantee was issued on the 1st of August 2018?
Not aware of the exact date.
Okay. When you made your report, you weren't aware?
No. This, as I say, I was asked to calculate that time and from the payment made. So I assumed that, rightly or wrongly, that the guarantee bond was in place. I was just carrying out the calculation, 56 days.
I ask why, because the performance guarantees were exhibited to Mr. Ikiki's, and it was in his witness statement, which you had reviewed when you compiled your report, where he said it was the 1st of August. Sorry?
Yes, sorry, I can't recall.
Okay.
As I say, I was interested on the dates. I focused on the dates to calculate the interest.
Yeah, but the reason why I'm asking these questions is because, as you've accepted, the performance guarantee needs to have been issued before the advance payments are, strictly speaking, payable. Yes.
Under the contract, yes.
Yeah, under the contract. That's what I'm referring to. And we've got the latest of the 3 batches of the 4.7 that was paid. The first was received on the 29th of August 2016, and the last was received on the 24th of May 2018.
Sorry, I'll just get my calculation.
Sure.
Yes.
Where do we find that? Where's your calculation?
Sorry, my assessment, my lord, is it's a summary of the compound interest.
All paid.
The original.
No, I can assist you. G for golf 2980. I'm looking at your Mr. Craig. I'm looking at your addendum report, but
Yes,
it's the dates of
paragraph
payment.
16. Yes.
Yeah, it's the dates of the payments that I'm interested in. So that's why I'm not the matter of compound interest or simple interest. That's a different discussion for another day for lawyers. But so I'm just looking at the dates, and I don't want to take you by surprise, but I want you to just to confirm that the first advance payment was paid on the 29th of August 2016, and the third and final was on the 24th of May 2018. Except you agree that, yes?
I agree, yes.
And how was that cross-checked? Was that by checking Reem's bank account details?
It was the bank account details of the payments, yes.
Okay. Now, the reason why I'm asking these is because you've included compound interest or whatever the interest is, doesn't matter, in a situation where the contract stipulated that the advance payment is payable when there is a performance guarantee issued. You understand that?
I understand that. I was following my instructions to carry out the calculation for those dates.
So just to be clear, your instructions were calculate the interest on the advance payment and don't worry about the dates. Is that right?
It was on the dates. When I looked at the date and I must admit, I didn't consider the guarantee because on the first date payment, I assumed that was in place.
Okay. Oh, okay, fine. So the assumption you operated under was that the guarantees were in place before July 2016.
When I was carrying out my, assessments.
But now you, okay, well, I think we now know otherwise, but let me put it this way. If indeed the performance guarantee was issued after the date of the if the performance guarantee was issued on the 1st of August 2018, would you agree with me that the interest can be deleted from your table?
It would be amended.
Okay, well, amended, deleted. I don't want to split hairs with you, but I think you would agree that it's potentially not recoverable.
I'm assuming that's a matter for.
Yeah, I understand.
Tribunal.
Understood. I want to deal with another topic, just again. Just still on interest, sorry. Forgot to ask you something. You said in your main report, I'll give you the references. Oh, sorry. Can I just ask you to look at paragraph 98 of your main report? Just need a page reference.
Page G1546.
Thank you very much. So where you say in paragraph 98 that you reviewed the documents and sought additional information, I'm advised there is no documentation supporting the payment of the performance guarantee, but that there is a performance guarantee in place. As I say, exhibit NA 13 off the top of my head to Mr. Akiki's witness statement, which you did have in your possession. That had the NA 10, that had the performance guarantees. You had that information.
Yes, I apologise. I may have done. There was a lot of information.
Okay, so this may be wrong.
This has been amended in my latest report.
Okay.
Sorry, the cost, this in relative to the 1% has been amended because I now have the actual cost. Yeah,
but I mean, I think that's a different point. I'm talking about the actual performance guarantee itself and whether it was issued or not. That was definitely within your possession, as you had confirmed.
Yes, I may not have seen it. That, as I say here, it was a performance guarantee in place.
Okay. I want to ask you about the IPAs. An IPA is an interim payments application.
Yes.
Yep. And correct me if I'm wrong. You'll definitely know better than me. But an IPA is made by the contractor to get paid as it completes its works. Is that right?
Not as it completes its work on a monthly basis. It depends on the contract. It's submitted monthly.
Fair enough. And an IPC is an interim payment certificate.
Yes.
Right. And that's the certificate that comes from the engineer?
Generally, yes.
Generally. And it says it certifies the payment that it should be paid?
Yes.
Now you say you in paragraph 105 of your main report, page G for golf 1548. You say that you have not reviewed the IPAs or the IPC's process, and you provide no opinion as to whether the IPAs were submitted properly under the subcontract agreement, nor do I opine on the IPC and invoice process. I have, however, reviewed and confirmed the dates of the applications and the date the payment was received. So in terms of confirming the dates of the applications, did you look at the I presume you looked at the application itself, or was that provided to you?
I was provided the applications
And you looked through all of the applications to confirm the dates?
and the stamp, yes.
And the stamp. And you checked, what documents did you check to confirm that payment was received?
I was advised by the bank, I was provided the bank details at the dates received.
Okay. You didn't check, though, to whom the IPA was addressed to, though. Is that right?
Correct, yes.
So you can't tell us if the IPA was addressed to the main contractor or Five or the engineer. Is that right?
That's correct.
Okay. When you looked at the IPAs, did you just look at the front sheet?
Just that, no, I also turned over to see the amount claimed to check against the schedule.
Ah, okay. So you can't, I'm going to run through some documents. You tell us whether you can or you can't confirm whether you saw the following. Did you see the quantification sheets?
I'm sorry, I can't recall from, there was.
Okay.
I
okay.
got provided the full document that was issued. I can't remember what's the documents are called behind.
So I'll tell you what, we'll do it in a way where you say yes, no, can't remember. It may be the easiest way for you, or you didn't log it, something like that.
Okay.
The quantification sheets, I think you said you don't recall.
I don't recall.
You didn't make a note of it in your report, obviously.
No.
No. Whether you didn't, did you see the approved work inspection requests?
No.
Did you see the monthly progress report? Sorry, hold on. Just hold on, Mr. Craig. So someone's just joined the hearing and they need to put themselves on mute. But let's carry. Mr. Craig, we'll carry on. So you didn't see the approved work inspection requests?
No.
And you didn't see the monthly progress reports?
No. But may I clarify those answers, please? That's not what I would normally look for in a interim payment application.
What you had agreed, I'm just going to summarize your evidence. If I'm wrong, you clarify it. You didn't see the quantification sheets. You didn't see the approved WIRs, work inspection request. You didn't see the monthly progress report. And you were saying that it's not something you normally look for. Is that right?
Well, that's correct. It's not what I would normally expect be submitted with an IPA.
Did you, I appreciate you've said that you've consulted the subcontract agreement. Do you remember looking at clause 6.3 of the subcontract agreement?
No.
Can I show it to you quickly, if I may?
Okay.
I'll give a page reference. So 6.3 is on the screen. It's page E for Echo 463. Do you see that? Do you see the screen? It's on.
Sorry, 6.3 above 6.3. Yeah.
No, here 6.3.
Yes.
And it says progress payment. And you quoted it in your report. In fact, is that G121525? So what you need are, yeah.
Sorry, my lord, to interrupt. As I say, I didn't carry out a review of the IPA as I put into my report. This was not undertaken. So I make no comment on whether, in my opinion, the IPAs were submitted correctly or not.
And but it's right to say that the IPAs were provided to you, as in they were made available to you, but they're not, as far as you're aware, exhibit to any of the witness statements in this case. Correct?
Yes, correct.
I'm asking you because you said you looked at the witness statement, so that's why I'm asking you.
I reviewed the witness statements, yes. I read through the witness statements, but just in relation to the quantum issues.
Okay. I'll move on. Let's deal with prolongation costs, and this is at paragraphs. Sorry, it starts at paragraph 74 of your main report. You'll forgive me for not having a page reference yet. I'm jumping around many places.
G1538.
Thank you, my lord. I'm always grateful. Now, you say here you understood there was a 9.9 roughly million claim, and you say that you understood as part of standard production of documents on the 10th of January that the defendant submitted its claim for prolongation costs, which you can summarize as follows, and you've outlined it in the table below.
Yes.
Do you see? You have that. Can I just ask you what document did you get this from, or what documents did you get this from?
I'm sorry, I just checked my exhibits because this was provided to me by Saravana, and it was a list of the claims. It set out the claims.
Right.
So you 6 individual items.
Yeah. So you were just provided with a table from Saravana Subia saying these are our claims for prolongation costs. Yes.
Yes, along with the supporting documents or the actual calculations.
Yeah, we'll come to that in a minute. But you didn't. It's not like you looked through a particular document or documents and you put this together yourself.
No.
Is that right? This is provided to you. This table.
Yes.
Right. I appreciate that you not assess, or you haven't included parts of your assessment the site establishment cost, so we can cross that out to make it make life easier. And the site equipment logistics, and number 1, by the way, was site establishment. Number 4 is site equipment logistics. I don't think you've included that either. And the extended premium for insurance bonds, that's not included. And the direct costs are also not included. So we can cross out, would you agree with me? Site establishment, number 1, 2 direct costs, 4 site equipment logistics, and 5 extended premium for insurance bonds.
No, the previous bond is included, and that's
Oh,
part
sorry.
of the amended.
This is the reduced amount. You're quite
The
right. I'm so
reduced amount
sorry.
of my amended report.
Yeah, fair enough. I confused myself because I'm looking at your main report, but I forgot that in your addendum you included it. Fair enough. And you'll be happy to know I'm not going to ask you about the extended premium. But what I am going to ask you questions about are the indirect costs and the overheads. Now, you said a moment ago you were provided with some supporting documents from Saravana. Yeah?
The spreadsheets, yes.
What's the spreadsheet? Tell me exactly what you mean by spreadsheet.
So if this is, I think it's Appendix 5 to my report.
Okay. Wait, the main one or the, I think there's an updated one.
It is revised, so it's Appendix 5 of the main report, and I've also included with the amended report because the indirect costs have reduced.
So you'll forgive me for breaking this down into very small bite-sized chunks. You were given a spreadsheet from Saravana, is that right?
Yes.
You decided because upon reflection with conversations with Mr. Lowe, that the delay period is not 720 days, it was 663 days.
Yes, from my initial instruction to calculate or to assess the cost prolongation up to the end of October, this was then changed to the 2nd of September.
Understood. And the updated report, who provided that? Who drafted that?
Sorry,
So the updated Appendix 5 that you referred to.
The Appendix 5 in my report is my review of the initial spreadsheet handed to me. In the amended report, I have just removed the 2 columns and I prorated for the month of November 2017 and for the September.
Yeah. You'll forgive me for being very pernickety about this, but I'm just trying to make sure I understand this because I think I'm struggling a little bit. The original spreadsheet, which I'll put on the screen, if you just bear with me one moment. I know you've got it, but I just want to make sure we're looking at the exact same thing. Appendix 5. Yeah, so I'll put this on screen, and it was from your original from your main report, G1577. Okay. Is this what you're talking about, the Appendix 5 assessment of indirect costs?
Yes.
Let me just make that easier to read. So when, this is the wrong way around, let me get it. So this is a spreadsheet of indirect costs. Sorry, I'm having all sorts of problems here. Right, here we go. This is the spreadsheet of indirect costs. You see that?
Yes.
I'm just going to zoom out slightly. This spreadsheet, who prepared this spreadsheet?
Reem, this was the basis of their claim, yes.
Right, so Reem provided this spreadsheet, which is an Appendix 5, the original Appendix 5.
Yes.
Right. And the way it appears here as your Appendix 5 is the way they gave it to you. Is that right?
Yes.
Got you. The amended Exhibit 5, you've called it Exhibit 5, but it's the same thing, I think. Appendix 5 at G2.
Yeah, sorry, yes.
It's okay, don't worry. It's all right. G2984. G2984. So I'm just zooming in to really make sure we're talking about the same thing. Indirect costs. Do you see that?
Yes.
Right. Who drafted or who created this spreadsheet?
That's my spreadsheet. As you'll see, I've reduced the spreadsheet to remove October and the September dates. You'll see the first yellow column, I say I've amended and prorated the costs claimed in the month because it was a full month of costs claimed.
That's fine. That's fine.
At the end. So this is the sheet that I've used to sample check those people claimed as being prolonged or the cost of being on site for longer.
Understood. That's all understood. I'm just trying to establish that the other appendix that we looked at, the original, that came from Reem, and the only thing you did with that, I'll come on to the sample check in a minute, but the only thing you did with it was reduce the period accordingly, pro rata, etc.
Yes.
Okay, got you. You said you sample checked.
Yes.
Sample check, spot check, I think it's the same thing. What exactly did you look at? How did you do your sample check?
I asked for evidence that that person named works for Reem, so an employment contract, evidence of payment of wage, and a timesheet for that person.
Right. We have to be very, you were slow, but it's me. I'm not that fast a writer. Right. You asked for evidence of a person named.
Yes.
Employment contract. Wage slips, I think you said.
Yes. Pay slips, wage slips.
Pay slips, wage slips. Yeah. Evidence of payment. And did you say timesheets?
Timesheets. Yes.
And how many individuals did you review?
I'm sorry, I can't recall. As I say, it was a sample.
Give me it's not okay. Let's put it this way. It's not
probably 10% at the most.
10% at most. And because when I look at your paragraph 81 of your main report, when you see me pause, it's because I'm trying to wait for the page to load up. Right, okay. G1540. Okay, when I look at your paragraph 81, you say, I reviewed a sample of the supporting documentation, which includes but not limited to timesheets, contract of employment, pay remittances, and etc. Just trying to understand what the word etc. means here.
Sorry, that was just for example. That might be just bad grammar. Sorry.
Okay, fine. So I can cross it out because what you have confirmed that you've looked at are employment contract, pay slips, timesheets, and that's it.
Correct, yes. What I would normally inspect when carrying out such assessments.
And that's it, right? I just want to confirm that's it. So you didn't look at the weekly reports?
No.
You didn't therefore cross-check to see if a particular named individual worked in a particular month or on particular days in that month to ensure that this person was working on site or was employed and etc. or was there on site or not?
When reviewing the timesheet and book to the job, that's what I would expect. So, but no, to answer your question, no.
No, because a timesheet, I can fill out a timesheet to say I've been at this all day in this office, for example, and I could be here, but equally, if I'm working remotely, I could just say I've been working all day and not worked at all. That's a general concept. That's a very basic example. You with me so far?
I'm with you, yes.
But the weekly reports would have included, or should include, let's put it that way more neutrally, the individuals or the job titles of those who are working in that week or month, etc., or day. Correct?
Correct.
But you didn't cross-reference it with those documents. Agreed?
Agreed.
Okay. And when looking at your updated Exhibit 5, which I'm going to put on screen for you, G2984. This is G2984. We've got here at the bottom what you've called salaries and wages technical.
This is a ledger from Reem's accounts of the people booked to that job. This is the cost of that person to the company.
Yeah. It's the cost of that person.
So it's not mine title.
No. Okay, that's fair enough. Understood. But the individuals here would include people who were involved in the design works. So an example is this individual, number 4. His name doesn't matter, but it says here designer. Do you see that?
Yes.
And we've got another one here, design team leader, design manager, and we go over the page. Senior designer, designer, and I think that may be it. Anyway, we've got some examples of people who are involved in the design works. Agreed?
Agreed, and they would not be shown on the site records.
No, but they would be off-site, so they could be in the head office, or they could be somewhere else.
Correct.
And their works, as I think Mr. Almaty accepted, maybe on Tuesday, their works could carry on regardless of the fire incident, no? Or certainly they could take place off-site. You don't need to be on site.
Correct.
Now, I appreciate you said 10% at most, but would you agree with me that the 10% wouldn't have included these individuals under the technical?
I would have spot checked because of the amounts claimed within that month. So it's a sample. It's the numbers that jump out as to why I would then request that information.
Fine, but it could be that you spot check the material coordinator or I don't know, senior structural engineer, someone that would be working on site as opposed to off site. Agreed?
Yes, it could be a mixture. I would not look at their designation.
Yeah, but even with them, it doesn't matter. Your previous answer still applies, which is you didn't compare it, of course, to the weekly reports.
Correct. I wouldn't have found them on the weekly reports anyway, as you say.
Yeah. Final topic is the overheads. Just bear with me. I've got multiple notes that I'm cross-referencing, so I'm just going to bear with me. Yeah. Okay. So the overheads, what it amounts to, in your opinion? Oh, actually, sorry. I'm so sorry to do this. There's one thing that actually I just remembered. I'm so sorry. I just need to go back to the spreadsheet we were just looking at right now. Yeah. So I just remembered this. The QA/QC. Do you see that?
Yes.
We've got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 12 people who've got QA/QC in their titles. Do you see that?
I see that.
And you recall Mr. Harish Nair's evidence earlier in the week where he said between August 16 to December 16, there were 2 QA/QCs. January 17 to December 17, 2 QA/QCs. January 18 to December 18, 1 QA/QC, and January 19 to October, November 19, 1 QA/QC. You recall that evidence?
I don't recall it, but yes, that's what he said.
Were you here on? Were you in the hearing?
I was listening. There was a lot to listen to. I've
Fair
been
enough.
listening.
Okay. Well, I hope I'm pretty sure that I'm right in saying that was the evidence Mr. Harish Nair gave. But then by that token, and he was someone who was on site, and we've got his name here, Harish Nair, QA/QC, number 8. Do you see that?
I see, yes.
And he's been claimed up until February 2019, and then nothing else afterwards. But in light of his evidence, in terms of your spot checking, it's possible then that the data here might not be accurate.
My lord, that could be correct. This is a ledger produced by the accounts team of Reem. These are the people booking to that job. So on that understanding, I carry out the sample against that. So there may be, as counsel says, discrepancies, but this was before any evidence, and this is based on the accounts ledger.
Okay, so going on to overheads as I promised, I'm now looking at paragraph 87 of your main report. Page 37, 58. Yeah, this is page G for golf 1541. And here you deal with the overheads. Again, paragraph 87, just so I've understood this, this table, was this provided to you by Reem?
Yes,
Okay. And you essentially give two formulas, the Hudson formula and the Emden formula. Is that right?
in my original report, yes, my lord. In my amended report, the compound just, sorry, in my amended report, I've changed that to consider an error in my calculation.
And the error in your calculation was what exactly?
It was the way I hadn't included in one of the cells the overheads and profit. So when it changed the calculation by 0.58% because it was to do with the profit in the year
Yeah.
and how Emden works.
And this was after, was this after your meeting with Mr. Lowe? Was he the one who prompted this?
No, it was just when I was carrying out a check of that because I had to, my lord, I had to change the period of days delay in the calculation. And when doing that, I then realized there was an error in the actual values used.
Now, when I say the preliminaries, do you know what I'm referring to? From the BOQs, the bills of quantity.
Yes.
They would account for overheads, wouldn't they? And set up costs, insurance, finance charges for bonds, etc.
That's a different matter to this contribution to head office overheads.
Well, it's only because you have relied on a formula, but would you not agree that the preliminaries would have been a better source of evidence to assess overheads?
No, because this is contribution to head office, my lord. The preliminaries are the running cost of the site. Mr. Lowe was mistaken in this. This is originally the Hudson, and this was overseen by the Emden, which uses the audited accounts. So it's the cost towards executives, the sales teams, the head office cost, and it's that contribution to that. This doesn't really have anything to do with the site.
Okay. The Hudson formula, that has an issue with double accounting, is that right?
That's why I, at paragraph 91, I include a table with the corrected. This is all in the SCL checker as provided. But as I say, I don't like to use the Hudson because this allows for a percentage that had been provided for overheads and profits within the tender. So Emden uses the audited accounts.
Okay, so it's not good to, we can't use the Hudson. Fair enough. Is that fair? We shouldn't use the Hudson.
It's not my preferred formula.
Emden is your preferred formula.
Sorry?
Yeah. Okay, so Emden is your preferred formula.
Yes.
So is that the one that we see at paragraph 94 of your expert report?
Yes.
And I just want to make sure I've understood this. The total annual overhead costs and profit, that comes from the audited reports that you've exhibited to your main report, correct?
Yes. Yes.
And in terms of the figure that comes underneath it, just explain to me, what is the 22,381,000?
That's an average of the 3 years of the overheads and profits. So that's from the audited accounts.
Right.
So overheads, whether the company made a loss for 2 years, as it did, and then profit, it still has the overheads.
Let's just look at the audits, because you looked at, you used the audited accounts for 2016, 17 and 18. Is that right?
Yes.
So I'll put it on screen, and it starts at page G1662. This is 2019, so we'll skip through that one. This is So this is the audit, the report for 31st of December 2018. Do you see that?
Yes,
So what you've done is you've gone through the 2018, 17, 16 reports, found the profit figure, added them together, divide by 3, and that gave you your average.
yes. My lord, may I state that I'm not an accountant. This is just based on my experience. It's a industry norm. And as I say, the audited accounts are complicated. I have checked with my accounts team here that I did follow the correct format, and that's what prompted my amended report. And just to check, I have carried out the checks that the values of the cost of sales and total overheads, I have used the correct values.
So I just want to make sure I've understood this for the profit. This is this is 2018. You use this figure here, yes? 1.5 million.
Yes, 1547.
Okay, so 1.5, I'm going to make a note of this. So 1.547278, that's figure number 1 for 2018. Agreed?
Yes,
So let's look at 2017. 2017 is a loss of 9,257,447.
correct.
So minus 9,257,447 for 2017. And then 2016, we've got a loss of 24 million. Do you see that?
Correct. Yes.
And so I can note 2016 minus 24,256,000. So what I'll do, I've got a calculator on my screen. I'm going to follow what you said.
Yes.
Combine all three, and we'll get an average. So 1,547,278 minus 9,257,447 minus 24566,000. We're in negative 32 million odd. So negative 32,276,169 divided by 3 to get the average, and we have a figure of minus 10,758,723. Do you see that?
I see that, yes.
And your calculation of 22,381,120.33 is wrong.
No, because you don't use that figure. That just means that there's been no profit made. There's still been overheads in that period.
Mm-hmm.
So you've got the annual head office overhead costs. So you've still got cost of overheads in that period. Just because it's negative doesn't mean you don't include that number. It's just that there is no profit. So the calculation is now 9.81, and that just means that it's pure overheads. There's point. So from my original calculation, there's just no profit made. So in this contribution to head office formula now, it's just for the overheads. It's based on the overheads percentage and the average turnover.
But these are the profit and loss. So this would be net, wouldn't it?
I'm not an accountant. I've just taken the numbers. I've run this through with my accounts team to check. I've carried out the correct, and it's the total overheads. So it's the total overheads less the profit and loss. So the total overheads of 33 million, less, that's the average of the 3 years, less the 10 million loss. So there's 22. That's where the 22 comes from.
Okay. All right. But you yourself, as you just said, are not an accountant, and you're relying on someone else's advice.
Yes, this is industry norm for a quantity surveyor. This is what the experts do. We will usually check figures as figures. This is nothing different than we'd normally do.
Right. Okay. Thank you very much. No further questions.
Thank you.
Mr. Carvelis.
Thank you, Your Honor. I will be very quick. Mr. Craig, can you please, the last point that you made, can you please confirm? Let me ask you, when putting together this report, did you do anything more or less than what you would normally do for the preparation of a quantum report?
No, I carried out the same as I normally would in making my assessments, carrying out my checks of the documentation available, seeking additional information. For example, the indirect, it's actually direct cost of the labour. Usually we find that a spreadsheet is submitted from the accounts, and normally the two experts would attend the offices, my lord, and just sample check that documents. Experts would normally agree that figure as figure to help the tribunal with a monthly cost.
We'll discuss a little bit the indirect costs in a moment. Can I further ask you, based on your experience, did you do anything more or less than the average quantum expert would do in order to appear before a judge at the trial or arbitration? Doesn't matter.
I believe I carried out what any other quantum expert would do.
Right. Let me take you back to this Appendix 5 of your report. We can look either the amended Appendix 5 or the original one. Let's look at the original one, which one is clearer actually. Easier to read.
Right, what page is the original?
Let's look at the amended one, Your Honor. G2984.
Yeah, I have the amended one, yeah.
Thank you. We will share it first, but let me ask again. Where indirect costs are required to be assessed, what is the information that usually the contractor who wants such indirect costs assessed provides the expert?
Based on my past experience, it's a ledger of all costs associated with the project, and this was just a matter of labour. Normally there are the running costs of the site.
But it will be, excuse me, but it will be in the form of the document which is...
Sorry, yes, it's a ledger. It's a ledger that's transported into Excel, and normally this is the document that the experts will work from.
Incidentally, if you happen to know, is this the same form of a document that a contractor would provide, say, to engineer to support an application for extension of time? If you happen to know.
It's difficult to say. Generally, yes. As I say, there would be a lot more costs associated with that.
Okay.
So generally, you can demonstrate your cost up to a certain point, and then it depends on the length of time. So claims.
Sorry to interrupt. I was meant about the format, not so much about the content. If the format would be, this
yes,
would be the
it would be a table. Yes, every claim I've seen, my lord, is generally following the same.
So they gave you this, and then what did you do? They gave you this ledger, and what did you do afterwards?
This is carrying out my sample check to ensure that the people that are booked to that job are actually employed.
Okay, sorry to interrupt you, but I have the obligation not to allow the re-examination go too far. So that's why I have to cut you. And I assume anyone who is required to assess a ledger like this if this person acts reasonably, would do the same, would ask for some backup information, correct?
Correct. When I have been on the other side, it's the same information I would look for when I was carrying out a review. If
Okay,
I was on that side.
Then let's look at this appendix, amended appendix 5. Let's look at the same, exactly the same table that my learned friend looked at, which is towards the middle of the first page, the ledger code 521105, salaries and wages QA/QC. I don't know if you have it, Your Honor. I don't know if you have it also.
I've got the document, yes. What am I looking at?
We are at page G2984. So
Yes,
we are the box. We are at the box which reads halfway through the document, ledger code 521105, salaries and wages, dash QA/QC. Can you see that?
I have it. Yes.
Mr. Craig, can you see it?
I can.
Okay, let's go now. The 8th entry is indeed Mr. Nair, Harish Prabhakaran Nair. Can you see it?
Yes.
A, whatever stands for, QA/QC, quality assurance, quality control, I assume, engineer, and then we have a number. Is this the monthly salary?
No, this is the cost to the company.
Per month.
Yes.
So it's a monthly figure anyway.
It's a monthly value to employ that person.
And it may include, and if it is a value and not the salary, the way I understand it is salary plus expenses,
Yes.
perhaps.
Lights, health, yes.
Yes, excellent. Now, can you go 1, 2, 3, 4, 5 lines above, which would be the third entry?
Yes.
We do not need to discuss the name of this individual. We see then again figures. What is the currency of this ledger?
Dirhams.
Dirhams. So am I right to see that this particular individual in the original period, the value, the cost was 330 dirhams?
Booked to this project, yes.
And then there was no cost of this individual for the next 2 months, which I guess it means that he was not on site, this individual, correct?
Or not working on the project, correct.
Or not working on the project at all, because you are correct, because there may be, we have individuals who were not actually on site, right?
Correct.
So for that particular month, this individual costed Reem £74. I made the conversion.
Okay.
And then on month 4, doesn't matter which one is it, it was 333.70 dirhams. It goes on and goes forward. Right? Am I right?
Yes.
And if we look carefully at this figure, it seems to me, to be honest, I'm just looking at it. I was only now looked at it in detail, not before, but it seems to me that there are only 2 individuals which were from start to finish, and where it seems that a significant part of their cost to the company have been included. It seems to me it's Mr. Nair and the individual just above him. Do you see what I mean?
Yes, and that would form part of my sample check. If you look at the total column on the right, you will see the value of 169,000, and I think that's Mr. Nair, 138 above that. They're the numbers that jump out to me as an expert, and they're the ones I would sample check. And then within the months where there are a number of people. So on the right-hand side is the cost of that person to the company for that duration.
Okay, thank you. Thank you. Thank you, Mr. Craig. I don't have any further questions, Your Honor.
Thank you very much. Right, well, Mr. Craig, that's the end of your evidence. You're free to go now. Thank you very much for coming.
Thank you, my lord.
Thank you. Right, Mr. Carvelis and Mr.
One moment, Your Honor, so that we stop sharing. Yes, now we can see you.
All right, is that the end of today's program then?
I think it is one, if I may, one about Mr. Al-Mahdi. I forgot to mention, and I should have. I think we must do him in the morning because it's 11 o'clock Dubai. He has religious duties later on. It's Friday tomorrow, and he has religious duties in the afternoon. And so I don't think we can have him later on.
Oh, Mr. Kostel, I understand that with being Friday, but if necessary, you can have half an hour with Mr. Kiki and start a little bit later. But shall we meet at 8 o'clock with a view to taking Mr. Al-Mahdi then? But if you need a bit more time, you can tell me then. Is that all right?
Certainly. Yes, certainly will do.
Very well, and then we'll go straight on to, after a 10-minute break, to the experts.
Yeah.
Good. Okay. Thank you very much. See you tomorrow.
See you tomorrow. Bye-bye.
Thank you, Your Honor.